Lordship, I mentioned a review petition that is listed before your Lordships tomorrow as item 1007.3. Lordships, on instructions, I seek to withdraw this review petition, Your Lordship.
You want to?
Withdraw. On instructions, I seek to withdraw this review petition, Your Lordship.
Follow.
Listed tomorrow before your Lordship.
We'll allow you.
Much obliged, Your Lordship.
We'll allow you to make a mention tomorrow.
Much obliged, I do.
My lords, with due
Number circular. So we'll get it listed in court. Oh, it's in
chamber tomorrow after.
listed before us. And then we'll allow.
My lords, with due permission, may I mention a matter? There are two IAs, Your Lordship, 29764 of 2026 and 34834 of 2026 in SLP number 693 of 2024, which is listed today as item number 17, Your Lordship.
Are you talking of the same IAs which you mentioned yesterday also?
No, Your Lordship, I didn't mention yesterday. Today is the fresh mentioning. Both the IAs pertains to the withdrawal, Your Lordship. May I request to mention it, and the same is listed today itself.
You want to withdraw cases?
Yes, Your Lordship.
You want to withdraw IAs or you want to withdraw the main cases?
No, Your Lordship, I want to withdraw the IAs. The IA of withdrawal, the withdrawal IA, I want to withdraw it.
Very disappointing prayer.
That
IAs dismissed or withdrawn.
Your Lordship, there is another IA 171815 of 2025 that pertains to the transposition.
That you wait for the transfer.
in the same item, I am also.
Just a minute, let her finish.
My lords, may I clear it once? There is this SLP number 693 of 2024. In the same SLP, I have filed two IAs, IA number 297 of 64 of 2026 and another IA is 34834 of 2026. Both the IAs pertains to the withdrawal of few petitioners because there is settlement with the builder.
So therefore, you are withdrawing the main case itself.
Please, Your Lordship.
And you want to withdraw based upon some settlement with the builder.
Please, Your Lordship.
Say on mentioning IA number so and so taken on board. Land counsel for the applicant petitioner states that during pendency of these proceedings, a settlement has taken place with the builder and consequently he does not want to press his specially petition.
Please, Your Lordship.
Specially petition is dismissed as withdrawn.
Is
Is it all right?
Please, Your Lordship.
in the same matter.
Tell us if there is anything in mind then.
I have one thing in mind. There are only few petitioners that needs to withdraw from the case, not the whole SLP.
Some of the petitioners, they have settled, not all.
Not
Deletion of name of some of the petitioners.
But there are others.
then you better you don't wait for the time to come.
My lords, kindly withdraw it. Kindly request that the same can be withdrawn.
Do you want to withdraw the entire petition in entirety or you want to withdraw on behalf of some of the applicant petitioners, please?
Some of the petitioners. So both the IAs have the name of those some of the petitioners which I want to
Mention
withdraw.
those numbers.
Yes, Your Lordship.
They have applied for the IA for 5 in
You are the builder.
Please, Millets.
You must be the builder. That's why the settlement.
They 7 of the petitioners. There are only 7 petitioners in the.
And settlement is with all 7.
Please, Millets.
Then what survives in the main case?
In fact, they have filed IAs for 5 in one IA and 2 in one IA, Millets.
Everything going out orally, they just show us the application. Meanwhile, you can start with the matter.
My lords, with your
In the same matter, I'm also withdrawing the 5 SLPs, my lord. Parties have settled in the matter. In
You
the
also want to withdraw
yes, my lord, I have the list of
because of some settlement.
settlement. Yes.
But you also want to withdraw the entire case.
Yes. Complete petitions have to be withdrawn.
will consent.
All these items you want to withdraw.
Yes, my lords.
Then counsel for the petitioner states that the dispute has been settled. And as such, these specially petition in past individual. And as such, the instant specially petition has been rendered infectious. As per for dismissal withdrawn.
Very well.
My lord, with your due permission, I'd like to mention a curative petition which is listed tomorrow in chambers. My lord, this comes from a judgment wherein a deed of hypothecation has been equated with guarantee and the lenders have been categorized as financial creditors of Reliance Infratel. My lord, my grievance is that my application for oral hearing is not reflected and I request that the matter be heard in open court.
This is also a very unique way of, very innovative idea. You file a curative petition. You have not permitted it to be argued in open court and still you are successful in arguing.
My lord, I'm requesting that the matter be heard in open.
Only if we allow your application and we find that there is something worth arguable point and we list the matter in court, then only you can argue. Otherwise, you know the fate of the curative petition.
My lord, but my IA is not reflecting the oral hearing IA.
Don't worry, don't
With
worry.
that request, I'm.
IA or no IA, when the curative is filed, we always examine, there is our own mechanism to examine it. We personally apply our mind, we see, when we don't find any merit, then we dismiss it.
Much obliged, my lord. My lord, this is curative 250
Thank
of.
you very much, thank you. Please don't argue curative like this. This will be a new practice then in this court.
I apologize, my lord.
My lords, just one last unlisted mention. I'm really sorry for the inconvenience, but this is an urgent matter. I had mentioned this previously on 25th of November and the 10th of December. This is a mining matter in relation to the state of Karnataka, in which a 3-judge bench has to be constituted. My previous mentionings were allowed by this honorable court. I'm really grateful for that. However, the matter has still not been listed.
This is the. This is that Samaj Parivartana.
Samaj Parivartana matter. Most probably in February and or March probably at least.
There you go. There's some urgency, my lords, because the mines are not being operationalized for over 3 years due to CEC observations.
We are already in February. Maybe we are trying because we have to manage certain matters that.
Most grateful. Most grateful.
Lord, I want to just clarify, I have given the IA numbers that has to be withdrawn. All the petitioners have withdrawn the case.
So all the petition mean then your SLP.
SLP is withdrawn. Deeply
Okay,
obliged.
thank you.
Deeply obliged, Your Lordship.
So now this order is the final order.
Yes, Your Lordship.
All right, done.
I'm really grateful, Your Lordship.
Thank you.
But in item 1, Lord, I have done 3 things. I have filed, my Lord, an affidavit in reply and 2 status reports, one for CBI, another for ED. And as per, my Lord, my reply, the approximate siphoning of the funds we are looking at right now is about 40,000 crores. And the investigation is ongoing. This is, of course, my Lord, bank's public money.
40,000 crore. But
40.
there are 2-3 disturbing things. One is that are you presenting CBI also?
Yes, yes, my Lord, CBI, ED both.
Now CBI says that on the basis of the complaint received from one bank, FIR is registered, matter using investigation. Meanwhile, from other financial institutions also, complaints have been received. How they say we want to register separate FIR?
We do. No, my Lord, what we have done is, I have taken specific instructions on that. The first FIR came from the State Bank of India. Thereafter, my Lord, other banks also intimated us about their, my Lord, alleged siphoning, etc. That is also now included, and it's a part of, my Lord, the investigation. Because we cannot have separate FIR.
These complaints, are these not, will these not amount to constituting a separate independent offence? Nature of the offence may be same.
Yes, my Lord.
Nature of the offence may be same, but in terms
The
of
transaction as, my Lord, used
the
in the judgment.
complainant is different, the time of transaction might be different, the manner of transaction also might be different. Ultimately, so therefore that will constitute an independent offence. Why are they not registering those?
Lord, that can be done. We will examine. Possibly, my Lord, there was a consortium lending. If that is so, then perhaps, my Lord,
In
separate.
the case of consortium and the lead bank have made a complaint, understandable. That will, provided that the lead bank says it is for and on behalf of all the banks.
No, my Lord, the lead bank says only for it.
Ah.
That's correct. No, we will examine that, and we are not averse to registering separate offences if these are separate severable transactions. There is no difficulty.
Actually, my lord, in this case, this FIR has been registered in 2025. The Bank of Baroda's audit report came in 2020, in which they had detailed the manner in which the funds have been siphoned out, etc. So the bank unfortunately did not, for 5 years, did not lodge this complaint with the CBI. Only in 2025 they seem to have lodged that
That's
complaint. And till today, my lord, only after your lordship issued notice, they have effected the first arrest in the matter day before yesterday. Till today, my lord, in a bank fraud of this kind, this is the largest corporate fraud in this country.
Now that it has been brought to our notice.
Yes.
And we will continue to monitor it.
Yes,
And we will ask them to file status report.
yes, that's what,
That will,
That's
that will
what-
have to be done.
that's what we want.
Milord, may I make a submission? Milord, I appear for R5. There are, Milord, 5 FIRs by CBI representing, Milord, a large number of banks. There are 3 ED, Milord, ECIRs based on that. There is 12,000 crores worth of attachments, Milord. There are, Milord, more than 100 summons issued to various people, Milord. They are cooperating. It's not, nobody is running away, etc. So, Milord, whether we have an SIT or whether they are going on, in the affidavit filed by ED, they have set out, Milord, all this what I am saying, that this is what they are doing, and they say that, Milord, they are doing it with great speed, Milord, etc., etc. That's for them. Now, as far as, Milord, I am concerned, I had a proposal to make. I am not, Milord, averse to an SIT or whatever, Milord, I am not opposing. I have a proposal, Milord, in the sense, Milord, since the government is here, it's a matter, Milord, of money. They say it is siphoning, I say it's not siphoning. But whatever it is, there could be business losses, etc., etc. I am not run away, I am very much here. Milord, if, through the good offices of the court and the government, if they can form a committee, Milord, of finance people like SBI, RBI, etc. And, Milord, let's have a look at it as to what is the amount due, and if this gentleman or his companies can pay in some staggered form, it can be, Milord, that is one way to look at it rather than going only for prosecutions. That's, Milord, my instructions, and I'm stating so on instructions.
Milord, I have something to say on that.
Thanks, Lord, to,
Only
they
a
have
minute,
taken
only a minute.
To my Lord, the Chief Justice, Milord, taking a call on the government.
Milord, only a minute, Milord. We, the banks, Milord, conducted a forensic audit by an outside forensic auditor, Milord. And the forensic auditor has said that there is siphoning and other things, Milord. Milord, we may perhaps not be able to, Milord, compound these offences, Milord, even if there is a readiness to pay.
Mr. Solicitor, in spite of what you are submitting, see paragraph 27 of the CBI report, you are dwelling on 17 capital A again. If the forensic auditor says that there was a breach not of loan terms but of collusion, then what is the question of stopping the registration of RCs in view of taking sanction? These are
at this point,
operations. Please examine.
I will answer my Lord's question. I have put it to the government, my Lord, to the CBI.
23 may
Yes, yes, your Lordship's question is very pertinent. My Lord, the public officials are also under the investigation. They are also under investigation. Number 2, the respondent number 5 and is possibly respondent number 5, the individual, filed suits in Bombay High Court, and there is, my Lord, an injunction granted not to act upon the forensic audit report, my Lord, on the ground that the person who signed the forensic audit report is not a member of the Institute of Chartered Accountants. I am not going into it. Banks have filed an appeal. Appeal is heard and the judgment is reserved. My Lord, I appeared for the bank as well.
I appeared on, that's a completely different issue.
Different thing, my Lord.
We are entitled to say a report is good or bad.
No, I am not on the merits.
That matter has been argued, so we'll wait for the.
Yes.
Your judgment will come soon in a week or 10
Even an
days.
injunction has to be subject to 41 of the Specific Relief Act. You can't get an injunction on registration of an
Injunction
FIR.
perhaps may not apply even
Absolutely
to
not.
an independent
We are
investigation.
not arguing that case here, my Lord. Question is, there is a report which, my Lord, declares me as a fraud. Report is issued by a person who is incompetent to do so. So I am questioning that, that's all.
There are two things.
Yes,
If there is an intention to
Yes.
siphon the public funds
yes,
from X to Y to Z.
yes,
From the very beginning, and if that has actually happened, then probably the solicitor is right in
Yes.
saying that this kind of offense can't be merely because you are willing to pay.
Agreed,
you
Lord,
pay.
agreed,
That
agreed.
cannot amount to condoning.
Absolutely right. But my lord, it is my case. There was never any intention. We have done business, my lord, for 40 years.
That is what precisely
Yeah.
has to be seen on the basis of the investigation.
No problem.
Now,
Investigation,
as my brother has pointed out,
No problem.
we will not allow this kind of impediment that 17A sanction, this and that. If the bank officers or some officers.
They are
found
also
to be-
under investigation, I am instructed.
If they are not involved, it's fine. But if they are involved, then they must also.
They are
face
in
the burden.
collusion or in any way accomplice, then they are also under the investigation.
That's okay,
I
but I am
authorized-
not opposing, I am not opposing anything. I have come, my lord, with a proactive stance. I have cooperated, I will cooperate. Whatever else your lordship will direct, we have.
What you are suggesting, Mr. Roki, that can be, that can only be probably from your side, it
Yes.
has come. Provided that after thorough investigation, someone said that it was a case where the default took place for the reasons beyond your control.
That's right.
Of the
No problem.
It was not misappropriation, misapplication or
That's
something.
That's
But
right.
it's a deliberate siphoning of.
But it can happen.
It's a criminal offence.
It can happen, my lord. People do go bankrupt.
even
It's
if
not
we
that every man, my lord, has taken money and run away.
Milord, I just want to.
Even
comment here,
even
because
if we ignore
if your
the-
lordships will just permit.
The audit report of the bank, the ED in their counter affidavit is saying that they have found evidence of forged bank guarantees being given by them. They have
And then itself is a
It's a
independent
criminal
offense.
offence. Therefore, I said it may not be possible.
forged bank
Compound that
guarantees,
offence for a merely
siphoning
because
out
somebody-
to all these tax havens. At least 26,000 crores has been siphoned out to these tax havens like Mauritius, etc. Not a single penny has been cuffed up. They have declared bankruptcy in all their companies. 1,78,000 crores of outstanding dues in these companies. 1,78,000. The only amount recovered in bankruptcy proceedings is 15,000 out of 1,78,000. Most of the money has been siphoned out. That gentleman, my lord, who owns all these companies, he has not been arrested till date. Till date, my lord, the main person, the kingpin of this whole scam has not been arrested. Only they arrested one officer of this company 2 days ago, day before yesterday, only because of this matter coming up.
No, not because of that.
We will not comment, Mr. Solicitor, but then it's a very serious.
Lord, we are before your lordships and we will have to ensure that your lordships' conscience is satisfied that the investigation is impartial and going in a right direction.
Today we are not passing any harsh order because someone may not take it that our order has caused prejudice, but we expect that your agencies must act fairly, independently and very swiftly. We would like to have status report every month. In 4 weeks, they must submit the report and let us see how we take the investigation to what logical conclusion.
Please,
If so much, such a huge amount has been siphoned.
it is.
Then we are.
Lord, this is not correct. This is absolutely not correct. Just banding figures like this.
No, Milord, just 2 points.
It's absolutely
I
incorrect.
just want to clear the impression.
When you are presenting.
I'm appearing for respondent number 4, which is the group of companies.
The company.
So here, Milord, I might just mention that the service, because the impression carried, I think last time when your lordship passed the order, was that service was effected and we were not appearing. In fact, we have received the papers only after the 31st of January, because I don't know which address they went to, etc. But anyway, now we are on record. We've placed our thing. We'll take some time to put in our response.
That's it.
etc.
Okay.
I'd be grateful for that. The second point which I want to mention, because a large number of figures have been bandied about, that in the last 5 years, 2 of the companies, Reliance Infrastructure and Reliance Power, have paid back a total of 20,000 crores of rupees. 20,000 crores of rupees. Now, this is a very, very important
The
element.
amount is 1,78,000.
Lord, this,
What I'm trying to get,
This
what
is not
that
correct.
people see, Milord, that those
This is
figures
not
are
correct.
bandied. What we are trying
Absolutely
to
bad.
project over here is that when a party has repaid 20,000 and these 2 companies are now virtually debt free. I mean, there will be obviously some requirement for working capital,
thousands of
etc.
shareholders.
But it's over, Milord, something like 50 lakh shareholders, small investors are there as far as these 2 companies are concerned on the aggregate. So this is, Milord, obviously a group which repays the amount. Now, we will, there, as your lordships may have seen from the, we don't have the advantage of the report, but we do have the Enforcement Directorate affidavit which has been filed. Where there's a series, the affidavit says that there's a series of steps and measures which have been taken in the last 6 months. So there's a relentless, my lords, effort. We are trying to ensure that the payments are made, and there is no question, my lords, as far as this suggestion of siphoning, etc.
Just one company.
Anyway,
Only
we will
one
bring-
aspect.
And therefore, my lords, I think the suggestion which was made by Mr. Roti is a valuable one. Most of the, you see the Enforcement Directorate affidavit also, that's all that we have. They have talked about public funds, etc., being siphoned away or being removed. Now, that doesn't seem to be the correct impression, which the Enforcement Directorate, but they're entitled to their view. So therefore, if there is some solution which can be found to bring this out, at least it reduces the issue, because that's the primary
There are
purpose.
two,
So let us see that.
let me respond, my lord, on two aspects, my lord. Number one, lord, in the forensic audit report, lord, it has come out that in some cases, the money is taken as a loan from one bank to repay the another bank. That may be, my lord, I'll have to check up, my lord, that may be the way in which, my lord, this is repaid. Second, my lord, this suggestion placed before your lordships may not be utilized in other forums that now Supreme Court is considering constituting a committee which will go into what is payable and how to pay it.
No.
Because there are suits and petitions pending.
Mr. Sheffield, we are not constituting any committee today.
Yes, my lord, right.
We are still expecting and we are hopeful that CBI and ED will do their job. They know how to do it. We are expecting them to perform it. If at all we find that yes, there is some kind of delay on their part, or if they are evading anything, then we might require to.
No, certainly, we are before your lordships, my lord, and
Lordship will see that, and then take a call. We have no difficulty. We are not.
Just two companies of theirs have outstanding, Reliance Communication Infra had 47,000 crores of outstanding dues. In bankruptcy, it was sold off for 455 crores, 1% of the total outstanding amount, and sold off to whom? To the brother's company. And the other one, my lord, Reliance Communication had 47,000 crores of outstanding dues. Just two companies have 95,000 crores of outstanding.
Lord, resolution is pending.
Sold off.
It's a public process. It's a public process. It's not that I am buying or brother is buying. Anybody can come forward and buy or not buy.
it's not buying also, it's a resolution plan being.
Unfortunately, IBC platform is nowadays being misused like anything.
That's,
You get the company, all the assets undervalued, then you indulge in a kind of an auction, which is also a completely a pre-planned game.
these kind of,
Only one thing.
Somebody from the family or close friends or someone comes and buy it.
Lord,
If the brother has done it, the value assessed is something different.
I don't know about blood. I am not aware.
Apropos what has fallen from my lord the Chief Justice, the government of India is also seriously considering this issue, my lord, in IBC. And I cannot, my lord, say much. I'm a part of the discussion, but it is under a very serious consideration.
Because every day the matters are coming, and this is one of the issues that every day we are facing.
My lord, the haircut is phenomenal, sir.
And the bankruptcy is declared by the very company which is facing bankruptcy. They ask one of.
Voluntary declaration, then your own people evaluate you. That evaluation is not even 1%, 10% of the actual market value, and then eventually you find out this. Unfortunately, this resolution professional or whatever designation is given, every day I keep on observing. Their conduct is also not above board. So let us see that after 4 weeks.
We will see that. No difficulty.
Please, sir.
Mr. Bhushan, all these facts are there on record now?
Everything is on record. Everything is on record.
Lord,
This
we will
Lord-
also respond, my lord, to these figures. They are not correct. We will respond.
So in reference to the order dated. January 2026. Respondent 4 and 5 have entered appearance. Their learned senior counsel seek and are granted 4 weeks time to file the counter appeals. Then say Mr. Solicitor of India, Mr. Tushar Mehta and Solicitor of India. You are representing both ED and CBI.
Both, yes.
Representing the Enforcement Directorate and Central Bureau of Investigation state that like this, the Enforcement Directorate and CBI have also entered appearance through Land Sources of India. The Enforcement Director has also filed an affidavit in similar substance suggesting that the investigations for the purpose of detecting the offences under PMLA as well as into the affairs of the group companies are going on. It is pointed out that ECIR stroke STF stroke 17 stroke 2025 has been registered in relation to the Reliance Commercial Finance Limited and Reliance Home Finance Limited. The investments made by Yes Bank between 2017 to 2019 in non-convertible debentures and commercial papers of both RCFL and RHFL are being examined. According to ED, it has been found that RHFL borrowed public funds from 33 banks, stroke financial institutions, and committed a default of rupees 7,523.46 crores. It is further claimed that 33 lenders have been able to recover only rupees 2,1106.28 crores, with a net default of 5,407.18 crores, which constitutes the proceeds of crime. As regard to default committed by RCFL, it is pointed out that 21 banks stroke financial institutions have been defrauded to the tune of 6,280.57 crores, as out of 8,226.05 crores, only a sum of is 1,945.448 crores has been paid. Another ECIR stroke STF stroke 26 stroke 25 has been registered in relation to Reliance Communication Limited, inter alia pointing out that the total outstanding amount is 40,185.55 crores, which constitutes the proceeds of crime. It seems that one ex-director of the company has been arrested recently and is in custody till 7th February 2026. Next paragraph. The third ECIR stroke STF stroke 14 stroke 25 2025 pertains to Reliance Power Limited. A detail of the factual details of the RPOWER showed entering into a power project agreement wherein forced bank guarantees are alleged to have been submitted. Defects. Were submitted. The total loss said to have been cost to the public money is 105.98 crores. Three individuals who have been associated with the aforesaid company have been arrested.
You hear?
Next paragraph. The Enforcement Directorate has further explained that it has searched 46 premises, issued 13 POs, and has attached 204 properties valuing 12,012.45 crores. Of main paragraph. That's right. Having gone through the counter affidavit of the Enforcement Directorate, it appears to us that the aforesaid agency is expected to the aforesaid agency must look into every possible financial transaction suspected to be which might have led to siphoning of the funds and determine the estimated value of the proceeds of crime. In this regard, the Enforcement Directorate is well advised to constitute a special investigation team of its comprising its senior officers and take all lawful measures to take the ongoing investigation to a logical conclusion. It may not be appropriate for us to express any opinion at this stage, except to observe that there has been an unexplained delay. There has been an unexplained delay on the part of the investigating, on the part of the ED.
For both.
ऐसे तो यहाँ तो दोनों का इकट्ठा लिख दो यहाँ पर बस ऐसे कर दो. Similarly, a report in sealed cover has been filed by CBI in bracket risk number 3, which has been opened and used. It seems that a formal FIR was registered on the basis of a complaint received from State Bank of India. According to CBI, the complaints received from other banks, financial institutions are also being investigated by enlarging the scope of the said FIR. Let's say a report adopted by CBI, apparently, does not seem to be in conformity with the procedural law, as is complaint, even if it pertains to the falsifying of public funds, is based upon its own unique set of facts and therefore would constitute an independent offense.
Also touch upon 17A. Also touch upon 17A. Also touch.
Furthermore, it is imperative from the CBI to investigate the conduct of the bank authorities as to whether the financial assistance was released on collusion and connivance with the management of the companies in default. In this vein, the reference by CBI to section 17A of the PC Act is totally misconceived. To direct that, regardless of any such provision, the CBI must look into the nexus, collusion, connivance, conspiracy, if any, and for that purpose, all lawful measures to taking the investigation to its logical conclusion be adopted. That's further. We may hasten to add that both agencies, namely ED and CBI, have already taken their own time in swinging into action, and any other delay will not bring and the further delay put it in a positive way. And we therefore expect that both agencies will act promptly, independently, fairly, and in a dispassionate manner as well. Yet status reports by both the agencies be filed within 4 weeks, post the matter for further consideration on so and so date.
Only
One last thing.
One small request, only.
Since your lordship is now monitoring this matter, there is now serious apprehension that the owner of all these companies, my lord, the person who owned these companies, he may flee the country. Now, they have not arrested him. They have not even
make that
issued lookout circular.
I am in India, I am before
They
the
have
court,
not even
I am
issued
not
a
running
lookout
away, I
circular,
am not going anywhere.
which will prevent him from fleeing the country. So many people, my lord, with tens of thousands of crores outstanding have fled the country.
There is an
At
LOC
least- at
against
least-
him, my lord.
There are several LOCs, I have not gone, I have not attempted to go, I am, my lord, working in my office in these companies even today.
That I think that having been issued, they can't.
And I am not going, my lord, there is no question.
Lookout order.
Lookout
Issue a
circulars are
lookout
issued.
circular.
There are several of them, not one.
They can't allow him to flee the country. At
Repeat.
least a lookout circular, even if they are.
Why is my friend making this statement, my lord? Is there any material to say that I have fled the country or I fled the country?
You have-
We have repaid 20,000 crores in the last 3 years. If I had to go, I would have fled earlier, not now. Why do you make this kind of statement?
Now
Just because of the press?
Because the court is monitoring the matter now. That's why I'm saying.
So where is the?
That's why.
Show me one stretch, one shred of evidence to suggest, my lord, that this man is running away.
Solicitor General, you, whatever necessary steps are required, because we do not want anything to happen which may frustrate the ongoing investigation.
I understand.
You
A
must take-
line from your lordship, my lord, would really.
You must take whatever preventive or other measures are required to be taken. We do not want that investigations are hampered at any cost.
Observation cases before drying.
My lord, statement, I will not leave the country without the leave of the court. What more is required? Just to make, my lord, allegations against us?
My lord, only a minute, only a minute. My lord,
At this
my lord, there is something I want to say at this stage.
Mr. Prashant Bhushan, learned counsel for the petition.
R5, my lord.
My lord, before your lordship dictates, my lord, one thing.
Huh.
My lord, I respect Mr. Rodgi's statement, but in past, my lord, he has also burnt his fingers. He made a similar statement in favor of one of the clients, my lord, before Delhi High Court, and the person did flee. I'm not saying, my lord, about this person.
But he came back and he paid 5,000 crores to this government. Let's be
But
very clear.
after 5-6
Once
years, but
he-
sometimes,
once he-
my lord, statement becomes, my lord, embarrassing for the
Once
council.
he is out of the country, what good is a statement? Once he leaves,
Below, then there is no, below, there is no reason to trust anybody. Then there should be no, why statement should be recorded about anything?
in a
What
matter
is this kind of argument?
What will say
Below, one
at
will
this-
flee
at
after
this
the
stage-
statement for, if
At
100
this stage,
people.
Mr. Prashant Bhushan, Land Counsel for the petitioner states that,
Very, very unfair
that,
make these allegations.
owing to the
he is responding.
alleged, owing to the amount of alleged fraud involved and the action now and the matter having being investigated under the supervision of this court, there is every likelihood of the principal accused fleeing from country. On this, Mr. Mukul Rothgil and senior counsel representing respondent 5
Yes, ma'am.
states that that his client will not leave the country without prior permission of
Of this court.
without prior permission of this court. Full stop. Mr. Solicitor General of India assures that all remedial actions,
Preventive actions.
preventive and remedial actions will be taken to ensure that no impediment is caused in the ongoing investigation.
Yes, certainly.
That's fine.
Because the
I am
other,
grateful, my lord.
because we haven't had the advantage, of course, of these sealed envelopes. We really don't know
They
what
are
is in it.
pending
We
investigations.
know this we know this a bit about the affidavit which the Enforcement Directorate has filed. So, Mr. Lordship may give us 3 weeks because at this stage,
4 weeks we are done
yes, for a counter affidavit.
for counting.
Yes. Please do that because this on denials. We are denying these allegations fully, because otherwise the court ultimately is going
We are
to
not-
the appellate remedy.
That's why we are very careful in
Yes, Your
using the
Lordship.
word.
We have seen them.
Yes.
We are also granting you time. 4 weeks.
Absolutely.
I am grateful, my lord.
Obliged to.
Lord, kindly come to page number 63, my lord. Lord, 2 years after construction of the overhead tank, kindly come to page 63, my lord.
Commercial loans are for provided with the banks. And I have paid everything. I have got no due certificate.
63, my lord. Lord, we have constructed a overhead tank, my lord, for the purpose of this Ilayangudi village, and my lord, we have
The water tank,
a water tank, and my lord, a small panchayat office is there. My lord, on a land, my lord, disused land, my lord, which was originally, my lord, a village pond and later classified as, my lord, a disused land. My lord, in fact, we have an ideological report also saying this construction will not anyway affect in other part of the land, my lord, which is retained still as a pond. My lord, the High Court, my lord, directs us, my lord, to remove, calling it as an encroachment. My lord. And thousands of, my lord, yes, my lord.
and water tanks, public use.
And 3,000 direct beneficiaries of this water. My lord, fresh matter, my lord, coming for, some delay also is there.
delay pending, issue notice returnable and so on so forth. Meanwhile, operation of the interim judgment of the High Court shall remain still.
Lord, R1 is the writ petitioner, others and all were respondents, my lord, along with the former councillors and all.
So notice returnable on so and so date. ये डिले भी इनको सुनकर के कर दे तो ज्यादा delay. Use 107 days.
ज्यादा नहीं है उसके बाद.
And then 380. So 900. Returnable and so on so date. Number 1 being the contesting respondent, the service on pro forma respondents is dispensed with. Respondent number 1 may be served through testing notice also. Meanwhile, operation of the interim judgment and order of the High Court shall remain stayed. Consequently, the water tank, there shall be no demolition of the Panchayat Bhavan or the water tank.
Grateful to you, Lord.
Hey, is your lordship. This is another interesting kind of bank fraud. It's, every day, my lord, they come out with
Serious objection for saying this one.
unique ways.
Absolutely.
Corporation हुआ था, 2 corporations में.
Your lordship should see how a genuine transaction is put into so much of court pressure. We should give us 2 minutes, my lord.
I appear for.
Genuine commercial bank transaction put into so much of pressure and anguish, my lord. Please see the number. We have recovered 116% of the loan amount. And now he wants an inquiry. Absolutely a roving inquiry without any basis. Please see the numbers.
They are so worried that they don't.
Go away.
So this kind of slings, yeah, dark. What the High Court says.
You have also to understand that this is a commercial transaction where the ledger value has already been
Recovered and more.
to the auction. Then
No, my lord, ledger value has not been recovered.
that's the finding, sir.
No, the company itself says that they have made a profit of so and so because
Oh,
it's one-time settlement. If your lordship now turns to page,
Kindly turn to page 30 of.
actually, my lord, at page,
Page 30.
we have analyzed at page 189, what was due and what has been recovered. By the, if your lo-
Come to page 9, 7.2. It
Yes,
is
7.2.
116% of the
Please,
ledger.
I've got the calculations. Lordship may see the
that is,
calculations.
on- that,
This is not trouble.
that is only the principal amount, not with interest. What was due with interest is, my lord, given at page 189. Otherwise, there would be no need for a one-time settlement. The only reason why they entered into a one-time settlement was because they said, and the bank said that, look, now the property has been devalued from 2,600 crores to 970 crores. Something very astounding. In 2021, my lord, this hotel was valued by the same valuer for the bank at 2,600 crores. 3 years later, in 2024, the same valuer values this same hotel at 970 crores, 1/3 of what he valued 3 years ago.
What was the mode of auctioning?
No auction. What they said was,
Two options.
It's a settlement.
what they said was, we will enter into a one-time settlement. And the one-time settlement,
Concept law, comparable, that was wrong. If you have a hotel use, the value is lesser than a commercial use, that's why it was done. And after I had paid everything and obtained a no use, this petition is filed.
How much was the total loan
Yes, my
liability?
lords may see, my lord, the court has gone into, lordship may see the sheet of paper, only one sheet, my lord, which we have given to your lordship.
if you're
I've
not-
seen the second sheet. Only 2 sheets were,
Tell us, how much was the,
my lords may see the numbers. Yes, your lordship may see the numbers. Loan sanctioned is
loan with
242.61 crores.
240?
I have given the sheet, my lord. I have given a sheet of paper with these numbers. Yeah,
Well,
please.
that's true.
Yeah, please.
that was the original
Yes,
loan.
one, please, Mr. My lord, loan sanctioned is 242.61 crores. Ledger balance at the time of OTS is 226.54 crores. Total amounts recovered is 414.6 crores. Profit of 172.
No, Mr. Venkataman, this 242 crore was given in which year?
I'll give the year in a minute. I'll give you the year in a minute.
March,
2015. 2015.
20?
15.
Yes.
Now, out of this principal amount of 242,
Yeah, they have paid so far, 400, including all the settlement, 414.63, line 3.
that 414 is paid only in OTS.
No. If your lordship sees the second line, 242 came down to 226 at the time of OTS because interest, always bank takes interest first. So once OTS has been compounded, The total amount recovered by the bank is 414.61 crores. And Lord, the date of declaration of the NPA is 31/12/2020. Bank sanctioned a one-time settlement of 265 crores.
No. This 414 crore is paid when?
No, my lord, since inception, when the final payment was made in 20.
Actually, my lord, at a glance, your lordship can see.
What is amount in 2023?
The COVID period, the hotel was empty, we were declared in NPA.
NPA?
The hotel is empty, it can't pay anything. That's across the country.
For 3 years.
When they created a default, we challenged it. We said, we are not a default, and the hotel is not establishment.
No, Mr. Vakil, if the account is declared NPA
Yeah.
and the assets of the borrower are valuing more than what the total due amount, in that case, normally, what these bank people do, they always go for auction. They don't allow a poor resident.
No, we exercised option twice.
100 square yard house, they will throw him out, will put him in auction because
We went for auction twice and it failed. We have exercised that option. It's not that bank has not done it. And it failed.
We questioned it. In COVID, the hotel was empty. We were suffering a loss of 100 crores. Lord.
And Lord, please see
Prior to COVID,
on the valuation.
1 minute.
prior to COVID, we were fine. COVID, Lord, created a problem for all kinds of, Lord, luxury establishments like hotels. We were questioning, Lord, our NPA. Finally, Lord, this was the figure which was being.
yeah, but this unfortunately settlement is in 2025.
Now, yes.
2024.
So before, in 2025, on 24th January 2025,
Yeah.
before that, when did you put the hotel for auction?
Yes, for 2 days. We have done it twice and it failed. We'll give the dates. Twice we have done the auction, we'll give the date for. Asset reconstruction auction will not took place in 2 dates.
But 2023.
P6 and P5, my lord. P5 and P6. One is, my lord, dated.
कहाँ है प्रिंट?
It happened in 2023. Yes, yes.
ऑफिस बेंच के लिए है बीच में फोन आपको 100 मार्क्स है हम मैनेज मार्क्स साहब
5/9/2023 and my lord, 29/11/2020.
5/9/2023, what was the earliest bid?
No bid was received in both.
After, well, in 5/1993, first of all, please show us the records of the auction. Please produce the record of the auction.
We'll do that. Will you last kindly
After
tell?
1993, 2023, when you are entering into an OTS on 24th January 2025, even a layman in Delhi can take notice of this fact that what is the value of a five-star hotel in Delhi.
Just see,
There was a moratorium stay for 3 years because of COVID.
Page
So, my lord,
So that 3 years is
High
over.
Court, because of a High Court order.
if your lordship
That
just
3
sees.
year is over when in 2023 you try to auction it. That
Yes.
means that 3 year moratorium period was over.
Yes, yes.
Now from 23 to 25, when anybody on the earth can take judicial notice of this fact that the value of real estate properties are rising, and you have a 5 or 7-star hotel here, you enter into an OTS, before that you don't make any attempt to auction it.
But we have done it. My lord, with great, there are 2 facts have not, well, the High Court has recorded 2 facts. There are
So
2,
please produce the records of the auction, we would like to see it.
Your lordship, just 1 second.
In fact, my lord, if your lordship turns to page 252, just turn to page 252.
my lord, nobody can then come and enter into a commercial understanding of an OTS. When not in IBC process, 90%. This is a case of a recovery of 116%. Your lordship is now, my lord, to say that this should be.
As a matter of principle, in the commercial wisdom of the banks or the financial institutions, we will not interfere. There is no question of it. But when we are talking of your commercial wisdom,
Yes,
we also know it very well that you are not a private entity.
no doubt,
The funds which you have are the public funds.
no doubt, my lord.
These are this money belong to the people of this country.
Yes.
Therefore, your commercial wisdom is for the purpose of giving undue benefit to a person, or it is to protect the public interest.
Which is not
That
their
what we
case.
have to be investigated.
Greatest respect. My lord, today, the case of the petitioner is a roving inquiry. He doesn't make out any case.
We are not concerned about the petition.
Yes, answerable to the
We
court.
must have been- we will go to the extent that the petitioner has been planted by some rival. Somebody wanted to buy the hotel, couldn't buy. Let us take it like that, worst part. But now that a fact has been brought to the notice of the court,
Yes.
we should satisfy our conscience that the things have taken place in a transparent
Yes.
and fair manner.
But which is what the court has said.
If your
We'll take the
lordship
findings of the court, my lord, but finding after finding.
just says one page,
Hotel was not, my lord, having any default prior to COVID. It suffered a default. The government of India, my lord, also issued circulars in regard to this period of default. If I have come out of it, they did try to sell. After that, I am back on my feet and I have paid. Is it a case?
Mr. Rati, we have no difficulty. Every day in, day out, in matters before us.
Yeah.
The plea taken by these very banks is, we will not enter into any OTS because the value mortgage by them is much more than my loan amount. Therefore, why should I go into OTS? This is the consistent stand they take before us. That we are not going to accept any OTS because we have an asset, we will auction it and we will recover entire amount.
But, my lord, is it appropriate that a man who suffers, my lord, great losses during COVID, not a single room in the hotel, my lord, was functioning?
No, we are talking of, had the settlement been in 2020,
Yeah.
things would have been different. The settlement is taking place in 2025. This OTS is in 2025,
Yeah.
when the entire, hospitality sector, the hotel, they are flourishing.
Yeah.
They have wonderful business, each one of them making money. A five-star hotel in Delhi has its own value. People know it very well. Who is going in the street, who is going to believe it that this hotel has a value of 300, 400 crores? When the value might be 4,000, 5,000 crore.
It's not.
Four valuation reports are on.
The debt was only 200. The debt was 200, 250. It is settled at 400.
why
Therefore, two things let them produce. First, produce your ledger books that if going by the rate of interest and all, as per the original loan agreement, what was the total amount as on 24th January 2025?
My lord, a special committee comprising of a retired judge and four other bank has come, but this OTS was decided ultimately not by the bank alone. It had 5 people in the committee headed by a retired judge, which decided what should be the OTS amount.
Then immediately produce this report. We would like to see the report of that retired judge also.
No,
Please produce that report.
I just want to make one small request, Your Lordship. I'm appearing for the bank. The committee consisted of 5 persons, a RBI nominee, a Government of India nominee.
if your lordship just says,
Besides the bank official, there's a RBI nominee, a Government of India nominee, and a shareholder nominee. They were all independent persons who had nothing to do with the banks playing any fraud in this case.
No.
And it kindly, therefore,
We have no doubt about their independence, Mr. Attorney. This all depends upon what the facts are.
Your Lordship's question is certainly well placed, but the question is,
It is something like whatever in a writ petition, all the counter affidavit is brought before us. Based upon that set of facts, we take a view. Our view, despite the fact that nobody will question our bona fide, nobody will question our independence, but still our view can be erroneous.
certainly, we go by that.
Because it's not properly.
We certainly go by that proposition, but the High Court said, I've looked into all these aspects.
Yes.
High Court goes into an independent of the settlement committee. High Court says at 12:30, I
These are
don't
detailed-
find these are roving inquiries for no good reason.
Absolutely a non-serious, my lord, non-serious, vague, bald, sweeping allegation on, my lord, a bank, on a my lord, we are not defending every transaction. We ourselves come. But, my lord, to say that therefore every transaction has to be, my lord, 5 million transactions happen every day. If you are going to put, my lord, a spokes to, my lord, through a process to say that this should,
Mr. Venkataraman, unfortunately, we are not saying that every transaction, but many of the transactions.
Certainly,
that
Lord,
take place,
we
and
are
particularly
provided.
under the direct or indirect umbrella of this IBC.
yes, yes, my lord,
These have become a very doubtful manner. A poor lady, a widow woman came to this court. She was before us with tears in her eyes. She wanted to pay 30 lakhs to a bank. They refused because they wanted to 46 lakh. She lost her husband. That's why the default was committed. We had to come to her rescue only to protect her residential house. When question of their case, they said, no. The value of the house is more than 50 lakhs. we have to recover only 46 lakh. Why we should enter into OTS?
Those,
This is the stand, these commercial wisdom people take before us. And when the question of a 7-star hotel come, the stand is altogether different. Why our conscience will not click? Why should we accept it?
May I only persuade on one aspect?
Please produce the record. I would like to satisfy myself.
your lordship will do that. I only want.
Right, so we will divulge. Let the original records of
The settlement.
the bank, complete details of the loan amount which was due as on 24th January 2025, the report of an independent valuer, if any, assessing the
Four valued groups will be
market
produced.
value of the hotel as on 31st December 2024, that is immediate before OTS, and other relevant reports be produced.
Well, there are four valuation reports converging on value, except for the one odd value report, which said, well, this is a hotel. We can't sell a hotel. Well, valuation demands, hotel cannot be sold as some industry. One odd valuer gives a report of a 2,000 crores, which my friend is relying upon, who says it's a commercial property. It's one whole building is left out from the loan. Loan is not, ultimately the mortgage is only limited to a few sections of the whole. He values the whole. He values the whole as commercial, contrary to four bank authentic valuers who all confirm what this value of this hotel would be at a given point of time. Four concurrent valuation reports. Well, the High Court spent a lot of time. Well, we'll certainly persuade your lordship. No difficulty. But only thing, my lord.
We have recently, incidentally before my bench only, we have dealt with the auctioning of 2 hotels in Kerala. We have seen the people come forward to buy hotels also. There is absolutely, it's not that people, the prospective buyers are not available.
We have no difficulty in producing.
Understandable. Suppose you say that I have tried my best in December 2024. I could not auction it. I did not get a single bid. And therefore, I have no choice but to go for OTS. We will accept it.
That's precisely what happened.
Commercial wisdom.
Precisely what has happened.
But even otherwise.
We will produce the record.
We'll
produce the
Just see one page, my lord,
Which I suffered in
page
COVID,
252.
Will be sold. Apart from that,
We are not saying.
it's not that I was not a default.
If a borrower,
Siphoning
Mr. Rotgi, if a borrower, small or big, if he can save his mortgage property by paying to the bank a reasonable amount, no difficulty.
Correct.
But not in this manner. If at all, it seems to be.
I think, Lord, your lordship will be satisfied on the manner. Lord, I'm sorry, but your lordship will be satisfied. I think.
Very hanky-panky
Lord, this, Lord, this is an litigant who is just throwing hammer and tongs will satisfy your
There's no
lordship.
difficulty. We'll show it, my lord.
Just
Absolutely no
see
problem.
one page.
Lord, the other issue will be, can you really upset
Of the
cases
paper
which are done in this manner?
When complete contrast cases come before us, we get disturbed only because we do not know what's happening.
Absolutely.
There we are with your lordships.
But your lordship will be satisfied.
We like to cut the oranges from the apples, certainly.
So OTSs are happening in this country. If not every
Yes,
pattern is.
sir, we say this with a sense of responsibility. An extremely genuine OTS transaction is what has been brought unnecessarily into scanner. That statement we will make it to
Say
the.
notice to respond number 4 and 5, 4 to 6 only at this stage. Number 1, notice to respond number 1, 4 to 6, and 4 to 6 at this stage. Then also report is produced.
Therefore.
I am obliged.
Oblige your lordships.
But office report shows on 4 earlier occasions SLP is dismissed.
May I just place my matter, I'll place all of that, I'll place that, I'm for the petitioner. This is a writ. The only question, I'm pressing in this writ is my prayer A. What is happening? I'm not seeking any relief in respect of the matter, which is prayer B. The only relief is prayer A. Your lordships will have at page 17. What is happening in the state of Telangana, my lords, is
Mr. Prasad, how many time your petition will be entertained?
no writ petition. What has happened is page 237, your lordships, I had come up in a SLP all the way, and at page 237 is that order where the liberty was given. My lord, just hear me for 1 minute. I see that, my lord, I have come in a SLP. Let me explain that, and the liberty was given at page 237. Your lordships will have that order.
File SLP. Please see the order.
Yes, because page 237 is the SLP.
Remedy. You file another SLP challenging this.
No, Amalas, I have filed only one SLP that was knocked out on the point of delay. The question was never considered. That came before Justice Narasimha's bench. The bench observed that earlier order. Yes.
Mr. Prasad, then
Yes.
that means if we dismiss the SLP, we decline to entertain SLP.
Yes.
According to you, the second SLP is maintainable.
No, this is a writ petition. This is a writ. Because the court indicated that please, we are not going to, because against the same, against the same order, the question, only the legal question, because in the state of Telangana, the court indicated that if you have to move, please move a writ. That's why that gave me a liberty. I am not seeking any relief in respect of this matter, but what's happening in Telangana, you lordships will just consider one thing, my lords. What's happening is reserve candidates are being counted if they are meritorious against general seats. So, my lords, which is incorrect, because the law is very well settled. If I on my own merit make it in the general, then it has to be treated as
SLP.
The SLP was dismissed on the ground of delay. So the High Court also didn't engage with this issue. The court at page 237, that's the order I had myself appeared, indicated we can't engage in this because I have dismissed an earlier order, earlier SLP against the same matter by some other party. Therefore, if you have to file a writ. That is why the liberty was given at page 237. And pursuant to that, I am filing. I am not seeking any relief or stoppage of the process here. I am only saying my lords will settle the law so that for future there is no problem in Telangana. That's the only prayer. This your lordships may not interfere. My lords may record my submission straight away. I am not seeking interference with this process now. Because otherwise every year this will be happening, my lords.
Thank you very much. We will not entertain this.
All right, my lords.
Great. Has already closed the first round of litigation up to this court with dismissal of SLP civil number 16170/2025. We are just to preview that the second round through this litigation is wholly misconceived, misdirected and not maintainable. Dismissed.
Great.
Was answer the petitioner, these are two matters, but similar matters have been decided.
But these are fresh matters.
But these are fresh matters.
Any matter already pending where we can tag.
Lords, as per the office report, no, Lords.
Issue notice, trustee, liberty to serve the state through spending conflict.
Most grateful, Your Lords.
In the earlier notice recommendation. Item 6. Already dismissed.
Please, Your Lordship. Lordship, this particular matter, as per the office report, this is already.
Yes,
Your Lordship.
Same order. Item 7.
Wait, please, Lord. But I've just set out these.
Just see the pleadings.
Now just see the pleadings against defendant number 17. I've just put them. Just hand that up. My lord may just see this. I've just summarized, I've set out the pleadings against 17. Just see that for a moment.
Like Order 1, Rule 10, discretionary relief, why?
Order 1, Rule 10 2, but just see the pleadings here. Just see that for a moment. This is not, it's a case which...
A case cannot be maintained against a shareholder when the cause of action is against the company. That is your argument.
No, there's nothing against the shareholder. Just see the pleading. Ultimately, even against the shareholder, there should be some pleading. Just see that pleading for a moment. Give me, just indulge me. I'm not asking your lordship to open the papers. I've set it out here. Just let me read that much. I've set out in extenso. I've reproduced it exactly. Just see, the solitary pleadings in the plaint with regard to D17, plaintiff from 38 to 107, it's a 90-page plaint. Para 18, the 15 to 19th and 21 to 28 defendants are shareholders of first defendant and are therefore beneficiaries of the trades done by first defendant on the plaintiff's exchange. Para 91, the plaintiff states that in view of the fraud and default committed by the defendants are jointly and severally liable to pay the outstanding amount with interest in respect of the said outstanding trades to the plaintiff. Para 111, the plaintiff therefore submits that this is an eminently fit case to secure the claim of plaintiff by attachment of all the assets of so-and-so defendants, since the liability of first defendant admitted by them runs into hundreds of crores of rupees, and the defendants are consistent with an intention to defeat and defraud the claim, which is manifestly evident by the act of restricting inspection of exchange designated warehouses. Para prayer is, this honorable court be pleased to pass a decree and order directing first, third to 41st and 45th to 50th defendant to jointly and severally pay 937 crores. Now they relied before the High Court on this para 87. Just see overleaf. Para 87, the High Court just merely sets out the para. Just see para 87. It is pertinent to mention that from September 2009, when the first defendant commenced trading on plaintiff exchange, till August 2013, the management and the affairs of first defendant was run by the 6th and 7th defendant. In fact, 6th and 7th defendants were actively involved in the transactions entered into by first defendant on plaintiff exchange. The entire conspiracy to defraud the plaintiff exchange was conceived of and orchestrated by 6th and 7th defendants. It appears that the companies owned by 6th and or 7th defendants and other companies firm, which in turn were owned by individuals who are related or connected to 6th and 7th defendants, benefited from or participated in the fraud. The directors, shareholders of first to fourth defendants are either family members of 6th and 7th defendants and or people accustomed to acting on instruction. I'm not a director. My father
was a director.
He resigned in 2013. Suit is filed in 2021. 8 years after he resigned as a director. No government against my father.
Sir, Roman 9, clause 9, Roman 9 of paragraph 87, that the shareholders are in collusion with the directors in respect of the fraud.
I'm not a shareholder.
You are a shareholder.
I'm sorry.
Paragraph 18.
It's a public limited company.
I'm a shareholder of the company. Your plea for dismissal is no dividends have been declared, so there is no.
I'm sorry, my lords. Please just see the law laid down by your lordships. This is this opens
law
up.
laid down by us is not to substitute a discretionary order.
No, this is not a discretionary order with respect.
Absolute discretion.
Not 711 lies even with regard to if the entire plain can be rejected against one defendant.
Don't make advance arguments on 711.
Your lordship.
Your prayer is under Order 1, Rule 10.
And under 711.
711A. If you argue on 711, you are out of court.
Your lordship's
cause of action is made out. Simple.
I'm not just see. I've set out the judgments also in this note. I'll tell you what. In Church of Christ, your lordships have categorically held that even with regard to an individual defendant, if the entire plaint can be rejected, 711 lies. Now there is no cause of action shown against me. Just making a bold statement.
Can entire plaint be rejected?
I'm sorry, Mlad.
Can entire plaint be rejected when there is an allegation of fraud against?
Entire plaint has to be rejected. There's no allegation of fraud against me.
Doesn't matter.
Just
for that. What's the remedy?
There has to be some basis.
Order 1, Rule 10(2) will make your defendant a party, a misjoinder. So for that, it's the discretion of the judge to keep him as a proper party. Simple.
I'm
It is not a necessary
saying,
party, is a
your
proper-
lordships have said that just by some artful pleading, look at the nature of the pleadings here. With this nature of pleading, every shareholder of every company will.
Please come to page 26, opening line of ground C.
Page 26, Milord?
Page 26, opening line of ground number C.
I'm sorry, just give me a moment, Milord. Grounds is the High Court failed to appreciate that in these circumstances, the petitioner only being a shareholder of, yes, I'm a shareholder of defendant number one. The description is only that I'm a shareholder, nothing else. Which means lakhs of, in every claim against a company, lakhs of shareholders can be roped in as defendants.
We agree with you. He is not a necessary party, but he can always be treated as a proper party.
There should some averment against a party. I can understand if there was an averment that apart from being a shareholder, I have in some manner done some act, any act, even one act. There's nothing here, not a whisper.
No, sir. Where is your most respected father in these days?
I'm sorry, Milord.
Where is your most respected father in these days? The whole country is eagerly waiting for red carpeting for you.
Look, only one thing, Lord, then let it be clarified that I can only be a proper party. Now, here, please see, if there's no absolute absence of any averment, not a single averment against the party, Lord.
Not a case where we will.
Please, the Lordships.
Appear for the petitioner, my lord. Lord,
Yes, I to wait.
yes. Lord, without hearing on the first day, my lord, I mean, I've got everything. Environmental clearance, consent to operate. No, I'll tell you, lordships, my lord. They've passed this order, and now the next date is April, and running, my lord. I know the stone crusher, the moment you hear it, everybody nowadays has a prejudice, but then, my lord, for 3 months, I'm a small entity. I opened in December.
So you can request the.
They just, I had lots to say without hearing me. At least issue notice to me, my lord.
Therefore, if you have not been heard, please go and apply to the High Court. We will make some observation. You can approach the High Court.
My lord, may I just, my normal course, I should be.
Approved by an interlocutory injunction order passed against it by a division bench of the Uttarakhand High Court. Interlocutory order dated 7th January 2026 passed by a division bench of the Uttarakhand High Court. One of the grievances is that the order has been passed without even hearing the petitioner. So since the High Court is now opening after the summer winter break on 9th February 2026, first we say like this, it seems to us that the appropriate recourse for the petitioner would be to approach the High Court to appropriate applications for its impleadment as a party respondent, semicolon, to seek vacation / modification of the interim order, and to bring on record the set of facts which the petitioner wishes to, set of facts on the basis which the petitioner claims that the song SAUNG, Song River, is a non-perennial river.
Can I just, sorry.
Since the High Court is opening after winter break on 9th February 2026, we request the High Court to entertain these applications and pass appropriate orders by preponing the next date of hearing. With liberty of formation, the special petition disposed of.
Can I just say one thing? I didn't interrupt, my lord. My submission is that the relevant stretch of the Song River is non-perennial. That is the permission. Lordship, that Song Rivers, that is not my contention. I have produced documents, the document which they gave, they gave is the reach of the Song River near Sankatiawala, Kala is non-perennial. That is my contention. Lordship will say relevant stretch of the Song River. That is my contention. My contention, even when I file a reply, is not, nobody can say the Song River is perennial or non-perennial. The relevant stretch, it's a huge river. This stretch, which is what the permission is given, the joint inspection report is on record, in which
your contention that you are away from the prohibited area of banks.
Sorry, my lord, sorry.
He's saying that the place where he's.
So, Lordship means relevant stretch of the Song River. That's
Claims and to develop non-perennial, that the site where the petitioners stone crusher, you have stone crusher.
Stone crusher.
Stone crusher is operational. The Song River at that near to that site is non-perennial.
Yes. I won't say anything for, I won't read. Lordship may read annexure P10, how this order came to be passed. I won't say anything.
Perennial and at one point the river is either perennial or non-perennial.
Lordship may see annexure P10. I won't say anything. Lordship may just read it. It was supposed to be listed along with a writ petition against my rival the next day. From this matter suddenly gets detagged and get listed. I won't say anything further. P10, Lordship may kindly see. I won't say anything further.
Anyway, we have requested the High Court to prepone the date and hear you. To apply immediately and get a
the consequences are grave. One day without hearing a crusher stop, the small entity, the whole.
Mr. Vasan, these are environment issues. Precautionary principle guides the area.
With natural justice, my lord, right? Without natural.
So a precautionary principle, when there is an RTI report, the website of the irrigation department shows it as a perennial stretch.
Which is why hearing us, and I've given a perspective. Anyway, Lordship has given me that liberty. I won't.
Lost sight of facts.
I'll leave it. But oblige.
There are two matters before your Lordship, 9 and 9.1. In a similar matter, Lordship, at page 212, lecture P6.
2013 का date में
Same order.
Double 6 stroke 25.
Others we represent Gaza Development Authority.
Yeah, they are here.
I will respond in 4 and respond 3. The matter is coming out on 23rd of February.
Responder 4 only or responder?
4 in 9 we are 4 and in 9.1 we are 3. Respond.
Accept notice on behalf of the council respondent. Counter affidavit can be filed before 23rd February 26.
Please.
That we will decide on.
Please. Oblige.
Then there is a letter. Item 10, there is a letter circulating.
Please. This is the third time, my lord, the petitioner has been deboarded forcibly and illegally by the MP police and the RPF with the RPF police. This is the third time this incident happened, my lord. He was not permitted to travel beyond his origination.
So what can we do?
My lord, this is
how do we examine these facts that you were dropped on the way?
Well, I have filed the documents, my lord, that police himself given that letter saying that we are deboarding you due to prevailing.
You don't have a place of protest in your state.
My lord, this is the case, my lord, where the
you have a right.
Assured, my lord.
You see, we are not curtailing your right. You have a right to protest. Peaceful protest.
My venue is not MP. It is the venue of Delhi.
Yes.
My venue is not MP. In the midway, we were.
Mr. Consul, have you applied to Delhi government authorities?
Yes, my lord, that letter I have annexed. Yes. No reply. Kindly see the letter which I annexed. 4th of October, I applied for letter. I gave a letter.
Have you obtained permission?
Well, permission. No reply has come.
If no reply has come, that does not mean that permission has been granted.
Well, even presume that even no reply has come after the representation is given, That means there are no grievance for conducting dharma at Delhi.
If you are ready to listen to us, then you please appreciate.
Yes, madam.
There is an earmarked dedicated place for conducting peaceful protests.
Yes, madam.
There you can have a political rally, you can have a non-political rally, you can have the farmers as you, whom you are saying that you represent. The farmers can come there, they can protest for their demands, whatever. That's a part of the democratic process, no difficulty.
Yes, madam.
And for that, there is an earmarked place.
Yes, madam.
So first go to that competent authority, apply and obtain the permission.
When I gave a letter, my letter, there is no reply.
The
When I even the lordship say that I have to apply before the competent authority, I gave a letter. Even if the letter has to be given in person, I have to come to Delhi at least.
Yes.
But even half of the way, I was deported.
How have you, has he engaged you?
Pardon, my lord?
How has he engaged you?
My lord, he is from same place.
So for the purpose of wakalatnama, for
No, my
purpose
lord,
of,
this is not the way, my lord. Kindly see this. There is a violation, a gross violation, 19(1)D and 19(1)A.
like to answer any question which we are asking you.
My lord, I am saying, my lord,
How did he come to sign your wakalatnama and papers?
as a counsel, I have to sign it, my lord, that I have filed a writ petition on his behalf.
You are filing without any wakalatnama?
No, wakalatnama I filed, my
Is
lord.
there?
Yes, my lord.
So he came to sign your wakalatnama?
No, he sent it by post, my lord.
Oh, like, he sent it from there. Now he has authorized you. Why can't you apply?
My lord, it is duly notarized by the local notary public.
Very good. So he has sent it now. You are his authorized representative. Not
I send it, then there is no reply. That's why my submission.
Go and apply, please. Ask your clerk, you can apply online nowadays. You don't know to, even you are not required to go.
My lord, I am not saying, my lord, because the question is that the representation has been given, no reply has come.
Well, thank you.
Thereafter-
Thank you. No case to interfere with you.
My lord, at least, my lord, kindly see, my lord, the last date,
No case to entertain this writ petition is there. The writ petition is completely vague, evasive, and full of misdirected governments. The same cannot be entertained, dismissed. Rule 5. Writ petition are dismissed.
Earlier, my lord, I was given permission to go to the High Court, my lord. I applied for the High Court, I filed a writ petition. There also they said we have no jurisdiction to entertain because you were deported MP.
No, but your standard is not permit to go to High Court. You are not, your standard is not less than Supreme Court. So you are rightly come to
Went to High Court order also I annexed, my lord. After that, after dismissal of the writ petition, I went to the High Court.
All right, thank
I pleaded before the High Court.
Thank you very much.
I have no jurisdiction to stop anybody from MP, other than beyond jurisdiction of Madras. That is the reason I come before Lord.
All right, thank you very much. Next. Item 12.
Lordship, I apologize in this matter. I'm sorry I couldn't circulate letter on time. Mr. Sibbal, who's leading me, is unwell. So he asked me to make a request. I got information very late. I tried to circulate, but I had surpassed the time. So I'm just requesting 1 week adjournment, Lordship. He's not well. I spoke to him. So.
Your monopoly right is expiring when?
Sorry, my lord.
May 2026.
Lordship, the patent will expire in May 2026. But there was an injunction till the time the division bench passed the order. So I'm just requesting for a week adjournment. There was an injunction throughout.
Next week.
Much obliged.
But if your lordship, so far as the SecPers lady is concerned, there is no allegation whatsoever. But please come to P4 at 61. That's the FIR. And if your lordships are kind enough just to see para 7 at page number 67. Apart from the invocation of 420, 406, etc. together, Lord, just come to para 7. Complainant, may I place it? May I place it?
Para 17 of?
Para 7 of the FIR, Lord, it said FIR will begin at page number 61. I would like your lordship to see para 7.
Yes.
The complainant ultimately advanced large sums totaling multiple millions of dollars, but as market conditions surged, accused person began dealing, eventually ceasing delivery. So the whole issue is not, it's really a commercial transaction that we could not deliver because of change in market conditions. Others are surplusage and nothing against the lady, Lord. Nothing whatsoever against the second respondent in the entire FIR. Nothing incriminating. She's just been roped in because of relationship.
What is the stage of the investigation?
Lord, I must tell your Lordship,
Yes,
I
yes.
stated, Lord, charge sheet has been filed.
Let it be investigated.
No, Lord, may I just say this? My Lord, charge sheet has been filed in the interim while the matter was pending in the High Court. Charge sheet has been filed, but I have not been served a copy of it, Lord. Charge sheet has been filed, it really makes out a civil transaction. I have not been served a copy yet because right now summons are not, process has not been issued. It's a case of not give or take of. Charge sheet was filed, Lord, but we don't have a copy. I can place that on record if your Lordship permits.
Appear before the charge sheet has been filed.
I'm sorry, Lord?
If charge sheet has been filed, then go and seek your discharge as per law.
But I leave it to your Lordship, but not purely a commercial matter where they say it's only a question of delay.
Commercial law depends upon that initially what were intention. If your intentions were right from the very beginning to dupe the investor, then you can't claim it a pure commercial transaction.
There was an MOU, and I must say this, for the second petitioner, there is, not this lady, there is nothing. May I just have a look at that for a moment?
Not a case that we can question.
Lord, may I just make a request, Lord? May I make a request then? Not the concern, I leave your Lordship with one more concern, but I was protected till a certain point of time. Kindly just see.
You know that is only clear. That will be lengthier. You will be released on bail.
Careful. And we'll take our remedies now.
Absolutely. The petitioners are aggrieved by the judgment dated 22nd December 2025 passed by the High Court at Calcutta in the Port Blair bench, whereby their revision petition seeking question of FIR number 34/2025 dated 13 July 2025 registered at Cyber Crime Police Station, South Andaman, has been dismissed. We have heard Sri Siddharth Luthra and our senior counsel representing the petitioner and report and preview the report. It is fairly admitted that that after investigation charge sheet has been filed. That means so, we are not inclined to entertain this petition. The petitioners, if so advised, may move an application for the discharge. Such an application shall be considered by the trial magistrate in accordance with the law. That's for the review to enable the petitioners to join the court proceedings. It is directed that the arrest of the petitioner shall remain stayed. Number 2. First petitioner company. It is directed that the arrest of petitioner's number. Petitioner is a company.
Sorry, not?
Petitioner is a company.
Not number 2. Second petitioner. Number 2, Latifa Banu.
Petitioners number 2.
And there are second, 3 matters, not the other individual petitioner. In matter
SLP criminal number 1790 of 2026 and SLP criminal number 12.
We'll get the name.
825 2026 and so shall remain stay subject to their surrendering before the trial court within 1 week and furnishing adequate bail bond full satisfaction of the trial court. So the learned magistrate shall be at liberty to impose such other conditions as may be deemed appropriate, which as may be deemed appropriate.
My lord, we make it 2 weeks is all I'm requesting instead of 1 week because one of them is based here. Flights are sometimes a little problematic. 2.
Right, 2 weeks.
And one request for discharge will not be influenced by the observations because there are certain observations on merits.
Nothing, Mr.
There are some observations on merit, menstruation, etc.
Thank you very much. Thank you.
Grateful.
Please, ma'am.
Yes.
My lord,
Description of sentence.
Yes, Mr.
Please. My lord, the first round, my lord, the constables came and the ground was that they were simply following the directions of their superiors. Now, my lord, here, they are the advocates and the advocate was throughout present during the commission of the offence. The High Court records that CCTV is not clear and therefore his presence is disputed, whereas, my lord, there was a test identification parade in presence of an executive magistrate and thereafter followed by, my lord, his identification in the court. And, my lord, two, my lord, the High Court records the phone which was found and which was used by this person, my lord. That phone was lost by somebody 6 months back. That's also wrong because it is recovered from him at the time of arrest. Please have a look, my lord, at page. And please see, my lord, he was described as an unidentified person and it was told in the first complaint that once I see him, I can identify. Therefore, a test identification parade was conducted, my lord. Now, please have a look at para 14, my lord. Page 15.
The test identification parade, because the FIR was delayed, was after 4 months of the incident.
My lord, there was an inquiry prior to that. There was an inquiry, my lord, and please see, my lord.
Lawyer's presence was not spelled out in the FIR.
No, my lord, please see. I'll just.
When he goes to the Home Minister and then the FIR gets registered in April.
It was.
We understand that.
Please,
there
please.
are some influence, etc. But still then the fact of delay.
Please.
We have to examine the identification in light of the fact of delay between the parties. And admittedly, this person was advising some of your partner.
No, my lord, he was never, my lord. The High Court records that his father was once upon a time an
advocate. Your father was the lawyer of your partner who is accused.
But my lord, he never appeared for me. Please see, therefore I am pointing out, please see para page 15, my lord.
Yes.
Para 14, my lords, may have a look.
Just to say, the point is that in a case where the
my lord, in the first round, my lord, when I pointed out that this may not be treated as a precedent, my lords have clarified in the order that in the peculiar facts and circumstances of the case, where there were constables simply, my lord, following the directions of their superiors, my lord. Here, my lord, please see the police officers and IPS officers, my lord. The police officers are a former MLA is before my lords, my lord.
The question is, it's a pendency of appeal. But the appeal will be heard, all this.
No, 4 months, 364A, life imprisonment, the evidence is on record, the findings are flawed.
High Court has made a fine distinction between the conspirators.
Therefore,
the superintendent of police has not been granted suspension. Your partner has not been granted suspension. It's the lawyer, the constable, and the former MLA who have been granted suspension.
But there should be the findings can't be brought contrary while granting suspension, my lord, with all due respect. The findings can't be contrary to the record, my lord. Please see, therefore I am pointing out, kindly have 2 pages, my lord. Para 14 at page, my lord, 15. Kindly have a look, my lord.
Yes.
It says, my lord, the applicant was throughout remained present when the act of ransom and kidnapping being made by the police officials, hence facts remains that the CCTV footage relied upon the prosecution seems to be not as much as clear. My lord, I was there, I identified. And 2, my lord, now please see the second finding.
Mr. can clarify that this observation has nothing, should have no bearing on merits. But the point is that once bail has been granted, why?
Lord, yes, I can understand, but this is an offense, my lord. Please appreciate a police officer is posted, my lord, 400 kilometers away. He comes to Gandhinagar from Amreli, and then he abducts. Then there is a transfer of Bitcoin where this MLA is involved. The advocate is present throughout the incident, my lord. Even prior to that, in the conspiracy, my lord, in the conspiracy right from 7th of February till 11th of February, they were in constant touch. The person who was released, that is Kirit Paladia, and my lord, this MLA and these lawyers were in constant touch on phone. Those are CDRs on record. There were meetings in the circuit house, the government circuit house, my lord. That is all, that register is on record.
You know, connecting this entire evidence to establish that there was a meeting of mind or that there was
Lord, there is no.
a preconceived conspiracy. All these are matter of trial. Because
Therefore, my lord, there was a.
Substantial evidence.
But, my lord, if the findings, my lord, are prima facie in contradiction to the evidence on record, just kindly have a look, my lord, what the learned judge records, my lord. Only one thing. Here, my lord, the High Court records that, kindly see page 16, my lord. What the High Court has recorded. That the mobile number 816, the last digit, claimed to have lost 6 months back. And then please see page 443, it says, there is a finding that further the mobile number so and so recovered from the accused Ketan as per the deposition of so and so. So there was a recovery, the High Court records that it got lost 6 months back. My lord, the findings are prima facie, my lord, in contradiction to the evidence on record. I can understand suspension, but please see, my lord. So at least, my lord,
assuming it's an erroneous order, even then we should not interfere. Unless we find a complete pervert order, going completely beyond jurisdiction, where the High Court.
Lord, this is prima facie in my respectful submission, my lord. Once the High Court records a finding which is contrary to the record, my lord, then what more perversity is required, my lord, with all due respect. And please see.
We have one counsel for the petitioner.
And two unidentified person, my lord. The High Court records he has not named. I was not actually knowing him. He came in Elantra car, my lord. That Elantra car he borrowed, that witness evidence is there.
The impugned order pertains to suspension of sentence and grant of bail during pendency of criminal appeal. We are not inclined to appeal with the same. Especially.
And this may not be treated as precedent, my lord. Now the police officers are in line. At least my lords may say that, my lord. They may not get the benefit of parity, my lord. If at all my lords are, my lord, not intervening, my lord, because of the rules, my lord.
It goes without saying that such a prayer, if any made by the who accused who are police officials, shall be dealt with by the High Court as per their own right.
Please.
High Court has already rejected.
14 and 15, my lord. 15 is. No, the other police officers have not come. Only one, and he has withdrawn. My lord, only one. Only one. That is Kirit Paladia. He is not a police officer.
Police.
No, my lord. Superintendent of police. His application is.
No, that has been turned down.
No, it is
the High Court made
the police inspector, my lord. Not the superintendent of police.
The superior police officer, the constable's bail were granted.
Constables were
The
granted.
superior police officer's bail has been turned down by the High Court.
No, only the police inspector, my lord. One of them.
Inspector.
The SP.
SP is two.
Yes, my lord. Now SP is waiting for
the
house.
inspector is down.
With the addition of this line, they will be taken care of.
Please, my lord. We are grateful.
Came out of 15.
Please, my lord. My lord, this is a case where petitioner is seeking his right of hearing on the bail application. But what is happening that bail applications are being filed by the litigants, and that is keep on adjourning without taking on the roster because of the heavy roster or any other reason. We have the compilation of इधर से दे दीजिए एक बार ये दिन There was a- My lord, we have the compilation of various cases where such type of practice is being done, my lord. Please, my lord, I have the list. I have prepared on my own. It is not the list of compilation of all such type of cases. But suppose the case is at serial number 3.
Sir, basically, ample report. So, there is a slightly unusual prayer made in this special petition. It seems that the petitioner has approved the High Court for grant of regular bail. The petitioner has approved the High Court for grant of regular bail in a case registered under section 115, 190, 191 in bracket 3, 324 in bracket 5 and 351 in bracket 3 of the BNS 2023. The petitioner was arrested in that case on 11th August 2025. With bail application, we approved the High Court for grant of bail and his application came up before the High Court for hearing on 8th December 2025. It was adjourned to 20th February 2026. That is for a period of more than 2 months. The petitioner then applied for preponement, but while the interim order dated 22nd December 25, his prayer has been declined on the ground that the bail application of his co-accused has already been dismissed. Next paragraph. During the course of hearing and on a query by this court, Hon'ble and senior counsel for the petitioner submits that there are numerous bail applications pending in the High Court of Punjab and Haryana at Chandigarh, where matters are adjourned where the dates are being given months after, and as such the bail applications are not being decided for a long period. On a further query and on an illustrative basis, he has submitted a chart of some of the bail applications which are pending since October 2025 and are currently adjourned to since May 2025 and are currently adjourned to different dates in the month of March 2026. You are for the state?
Yes, Your Lordship, I am appearing for state.
It's not your fault, maybe.
Yes, sir.
Your fault may be that because you might be taking date or you might not be producing the record. But this is not the way the High Court should deal with bail applications.
Please, Your
If you don't want to grant bail, you reject it. For 6 months, for 1 year, you don't decide the bail application.
Lord, I have given the suggested measures also, where the state is seeking time for a filing status report and on any other, there are various reasons. for which the bail applications are being pending. There can be mechanism, my lord, because 7 days time is always given in regular bail in High Court. Within that period, they should file the status report so that it cannot be adjourned. Because once adjourned, then it goes after 3 months.
We had introduced a system there that when you file the bail, we don't know now, you file the bail application, you will give an advance copy in the AG office, and when after a gap of 1 day, the bail will be listed and the IO will remain present in court.
Earlier it was being listed, but now.
Of course, now with the hybrid system, the IO can appear even online, but the bail application could be decided the very third day.
Yes. But now it is listed after 7 days. And even within 7 days, no reply, no status report, no.
And that's why when we ask for the disposal, only these bail application disposal is shown. The regular matters are still pending there. All 1985-86 RSAs of criminal appeals, everything is pending.
Please, ma'am. It directly affects the liberty of the litigant.
Next paragraph. ये सारे सर्विसेज से जाते हैं क्या इन्होंने लाइफ में कुछ प्रॉब्लम At page 22, you can't blame the judge on a request made by counsel of the by the petitioner.
What is happening in some of the case is not being taken up. Thereafter, the counsel check the list. Then what is that on the request of the counsel adjourn and status report is awaited. There are also some of the cases. I have given 7-8 suggestions, my lord, how it can be mechanized or improved, madam.
The biggest problem is that there is no orientation, there is no training system, there is no sensitization program of after all they are high court judges, they must themselves realize it.
My lord, I have given the copy.
ROPs have also been produced in order to show that how the matters are being adjourned repeatedly, how the bail matters are being adjourned repeatedly. Next paragraph. All that we wish to observe at this stage is that we are extremely disappointed to see as how the prayers pertaining to the liberty of individuals are being dealt with. It may be true that the dockets are very heavy and there are other matters which do require prioritization. But amongst the miscellaneous matters, nothing can be more important than the decision of the fate of, nothing can be more important than deciding the fate of the prayer to grant or refuse bail. Next paragraph. We expect Honorable Chief Justice of the High Courts to take some remedial measures. इससे पहले एक करार दारू कर दो. Almost shocking response is working well. It is equally disturbing to know that in the Patna High Court, bail applications are not listed even for preliminary hearing for months. More than 15,000 matches are pending. One of us, Mera Likho, vividly recollect various matters coming to this court only for seeking direction only for listing of their bail application before Patna High Court. We have no reason, next paragraph, we have no reason to doubt that Honorable the Chief Justice of the High Courts are cognizant of such prevailing conditions where the High Courts unfortunately are not even able to decide bail applications on time, within a reasonable time. This is happening despite the fact that on occasions, this court has indicated timeline for adjudication of such type of matters where there is an inbuilt urgency, keeping in view the very nature of a relief sought. It seems that those orders passed by this court have not been able to bring the desired sensitivity as a result of which, due to which the High Courts have apparently not evolved any robust mechanism for time-bound adjudication of the bail matters. Next paragraph. We are conscious of the fact that listing and prioritization of the matters for the purpose of listing is the exclusive prerogative of the Chief Justice of the High Courts, they being master of their respective rosters. So, however, if the people are languishing in jail, semicolon, their bail applications are not being even heard, and they are completely in and there is a complete uncertainty as to when will they be able to know the fate of their applications, comma, it seems that this court is under a bounden duty to lay down certain mandatory guidelines. However, before we do so, We direct the registrar generals of all the high courts to send complete details of the anticipatory and regular bail applications pending in the respective pending in their respective high courts, along with the date of filing, date of decision, or the next date of hearing. All the bail applications, such details shall be furnished for the time being in respect of all the bail applications which came to be filed on or after 1st January 25, filed on or after 1st January 2025. So, bail applications filed prior to 1st January 2025 are also pending. यहाँ पे है ना anticipatory bail application, then stroke है ना applications for suspension of sentence, three category. However, if such applications filed prior to 1st January 2025 are also pending, details thereof shall also be furnished. Next paragraph. Adverting to the case in hand, we find that the bail application filed by the petitioner is coming for hearing on 20th February 2026. We request the Honorable Judge to decide the same on merits, either on the date fixed or prior thereto, if an application or prior thereto, provided that the petitioner seeks preponement of date. Next paragraph. Within 4 weeks, post the matter for further consideration on so and so day. उसमें लिखना, all the state governments are directed to fully cooperate the high courts for early and time-bound adjudication of the bail applications, stop prayer for suspension of sentence. The High Court sentence to the states should be ready with the relevant information as and when the bail application is listed for hearing, provided that a copy thereof has been handed over to, has been submitted in the Office of Advocate General and or the public prosecutor at least 3 days in advance, at least 3 days in advance. In such like matters, the investigating officers or the authorized officer can be permitted to appear online also. Next paragraph. The Registrar General of the High Courts are further directed to circulate this order amongst the Honorable judges of their High Courts who our fervent appeal to them for expeditious disposal of the pending bail applications. Next paragraph. The Honorable Chief Justices are also requested to revisit their roster of listing arrangements, and wherever they find that there is a mismatch between the total pendency and the bench allocated for deciding such matters, they may consider the desirability of listing the bail matters before. They may expand the roster for listing of the bail matters. Post the matter and so on, so that.
May I make one more submission, my lord? My lord, in cases of suspension of sentence, sometimes what is happening that custody is more than 7, 8 or 10 years. Suspension of sentence bail application either pending or disposed of by listing the appeal. But appeals are also not being heard. And 7 years custody, 10 years custody after conviction of total, my lord may also call the record. The appeals in which custody is almost.
Sorry, Dr. Pankaj, that there are the system that has its own difficulty. If you start taking your only criminal appeal, the matrimonial appeal, the matrimonial cases, the other admission matters, academic matters, those get delayed. So some balancing has to be done.
There is no doubt that that is heavy roster, but 10 years custody is something.
No, undoubtedly we strongly disapprove rather if there is custody of more than 10 years, even normally in a case of life sentence, barring a few cases where death sentence is there or the crime is so heinous that life imprisonment means that he has to spend 40 years or so. In such cases, there is no question of granting bail. But then you pass an order, dismiss it, matter ends. Somebody would have they have a right to go and appeal, let them come. But keeping pending is what is bothering us. You pass an order, that is prerogative of the judge. Whatever order they want, they let them pass. Right, let us see.
Items 36, 37 are those Bengal SRs. In the sequence, it was supposed to come after 16. So, is that being taken up?
We'll take up soon.
Because sequence was issued this morning. It said it's after item 16. Items 36 and 37.
After this,
fresh matters.
1 or 2 fresh matters are left.
Yes.
After that,
these are fresh. 36, 37 are fresh matters. Bengal SIR.
Those will take with us.
I'm grateful.
Just a minute, only 2 matters are left.
Very well.
I'm grateful.
Yes, item 40.
Yes, my lord, I appear for the petition.
You can argue from there now.
Only difficulty is, my lords, the elections are slated to, my lords, on Friday. My lords, my objection was dismissed only on 22nd. Also on 23rd, immediately I have moved the High Court. Immediately before the High Court, I have moved, my lords, the very next day.
They wanted to oust your opponent at this stage of nomination itself.
No,
You don't want to face in the election.
No, my lords, the only difficulty is that, my lords, I moved the High Court immediately on the next day. My lords, no hearing has been given.
If you win the election, then he is out by itself.
That is it. my lords.
Okay?
May I only make one request, my lords?
23rd.
Options open.
My lords, I'll withdraw this petition. My lords, only request is that, my lords, this objection I may be allowed to raise at an appropriate stage.
You are entitled to.
Because, my lords, the difficulty I'll face otherwise is that the order of the returning officer which is against me.
Learned counsel for the petitioner seeks and permit to withdraw this petition with the liberty to raise all the, to raise all the contention at an appropriate stage. Order to court.
Very good. I'm highly.
Item 41.
Lordship, almost more than 90% encroachment has been removed from the government and forest land, Lordship. This fact is already acknowledged by the respondent number 225, Lordship. May I read, Lordship, next year P5, Lordship. Page number 36, Lordship.
But why not remaining 10%?
Actually, Lordship, but there is a one beam, Lordship.
My lords, I am appearing for R1, my lords, for Miss Chandel, my lords. My lords, my only two submissions, my lords. The first is, my lords, in the month of May.
That pillar of the house.
My lords.
Beam.
My lords.
Normally they don't construct pillar in Himachal.
My lords.
But that beam or whatever support to the roof.
My lords.
That is coming in the government land.
My lords.
And if that is removed, the entire house will fall down.
My lords, they were new while they were constructing, my lords.
Like they knew.
Who is he, Lordship?
They were new the consequences of my lords. Still they constructed, my lords.
Who is the Lordship? In which capacity is he appearing?
My lords, again, in the month of January, my lords, the petitioner again encroached the government land, my lords. They are using as a warehouse. They have kept their the materials, my lords. They are
issue notice, returnable and so on. So that you appear for whom?
My lords are R1, my lords. Miss Chandel, my lords, R1.
R1.
My lords.
Or you are the complainant?
My lords. Original petitioner, my lords.
Original. Then say, so and so accept notice on behalf of respondent number 1. Counter affidavit can be filed within 4 weeks. Then say, meanwhile, the parties are directed to maintain status quo at the site. That means that neither the house of the petitioner shall be demolished, nor the petitioner shall be permitted to raise any fresh construction. So, if the petitioners indulge in raising fresh constructions, respondent number 1 and the authority shall be at liberty to bring it to the notice of this court, and in that case, the petitioner will be liable to face the consequences.
My lords, meanwhile, they kindly directed to remove the to clean the, my lords, the path. To clean the path, my lords. They have
no path.
As per my instruction, my lord, they have kept their
There is no path.
materials to construct the buildings. my lord.
You take out the photographs, you will file counter affidavit and you place on the court the complete site plan, photograph and show that how the passage has been improved. Then we'll see what is to be done.
Obliged.
Deeply obliged, Lordship.
What do you think? West Bengal board.
Very well. 36 and 37 are fresh matters. 21 is after notice.
Judge, may I just, I've prepared a note. I'm appearing for the petitioner in 37 and also in 21.2. So I just have a note because we need some urgent orders here. So would your lordship please just take this up along with, I'll request the court master to hand in IA 26838 of 2026. You got a copy of the note?
21 is on the board, that's also, that's also ECI 21, which is the 21.
You are appearing in item 37.
I'm appearing in 37, but I'm pressing just now because this is a matter.
37 is by Madam Mamata Banerjee.
Yes. And
there is another matter, 36 by Mr. Joy.
I'm in 36. I'm in 36.
Yeah.
32 petitions.
Because it's connected to 21 and I'm requesting the court master to hand over its 21.2 IA 26838 of 2026. So, because the cross references in my note are to those particular documents. So I'll just request that. And I'll place this quite rapidly along with the writ petition. And there's an earlier IA also, 1884. Would your lordship have the note?
Note. All right. Yes.
Now, my lords, with your permission, may I just place, my lords, since
Go behind it.
Pancholi
Don't
was
push
not
me.
there on, in the bench on 19 January 26, may I just place this court's order of 19 January 2026?
Page 30.
19 January, what is the same order when Mr. Sibal wanted us to issue some direction and
Your lordship
before
has
the
already passed direction, so this is just in, in furtherance of that. Your lordships have that.
Page 30
Maybe that order of.
It's at page 30
of the IN.
of the IA.
Page?
30.
Not confused.
That's it.
IA 26838. Your lordship has that?
Yes, yes.
Yes. Justice Pancholi, I'll just go through this so that we'll get the thread.
That order starts from page 31.
That's right. Para 2. It appears that approximately 1.40 crore individuals have been issued notices for the purpose of document verification. These notices are broadly categorized into three parts, mapped. That is the category of voters who are linked with the 2002 SIR, unmapped. That is the category of voters who are not linked with the 2002 SIR. And three, the third category involves logical discrepancy, accounting for approximately 1.36 crore voters. The documents brought on record by the parties indicate that within the category of logical discrepancies include inter alia mismatch of the father's name, a mismatch of the parents' ages, a difference in the parents' ages of more than 50 years, a difference in the grandparents' ages of less than 40 years, and those having more than 6 progeny. With a view to enabling the person who are as of now included in the category of logical discrepancies, we deem it appropriate to issue the following directions. The names of the persons figuring in the logical discrepancies may be displayed at the Gram Panchayat Bhavans, public places in every taluk and block office and every taluk subdivision, as well as the ward offices in the cities and the urban areas. Persons likely to be affected are permitted to submit their documents, objections through their authorized representative. Such an authorized representative can even be a booth level agent. There shall be an authority letter in favor of such representative, whether signed or thumb marked. Documents and objections may be permitted to be submitted at the Panchayat Bhavans of block or block offices. The Election Commission of India shall issue instructions for providing an additional 10 days time for the date of displaying the list in a Panchayat Bhavans block office to all persons who have not yet submitted their claims, documents or objections to do so within the extended period. The state government shall provide adequate manpower to the Election Commission of India and the State Election Commission for deployment of Panchayat Bhavans block offices to handle documents, objections and hear persons likely to be affected. In this regard, we direct each district collector to meticulously follow the instructions issued by the Election Commission, state government for deploying adequate staff and forces for ensuring smooth functioning. Director General of Police, West Bengal, Superintendent of Police in the district and the collector are instructed to ensure that there is no law and order problem. All affected persons may, in addition to being given an opportunity to submit documents, materials or objections, also be heard at the time of either in person or through the authorized representative accompanying them for the purpose of making an appropriate decision. The official will receive the documents or record a hearing to the affected person, may also certify the receipt of documents, and that important direction in para 10, Madhyamik class 10 admit card, which discloses the date of birth of the candidate, may be submitted apart from the Madhyamik pass certificate during the.
Direction number 10 was issued.
Yes, yes.
Because we, at least personally, I had the advantage of my two brothers from West Bengal being with me.
Yes, yes. That was,
and they were able to point out that this is the way in certificates are issued in West Bengal.
That's right.
Therefore, because of their having been pointed out, so that's why we included in 10.
Now, Milos, may I request you to take up the note so that we just very quickly and rapidly go through that. So please see, this is a brief note on behalf of the petitioner. Your Lordship has it. That's the heading right on the cover page. Sorry. Of the note, which is a snapshot. Now, the number of days left for the final publication.
This separate note you are talking.
Yes, well, just to save time, this is the full, the submission which we are going to make and the request. Number of days left for final publication of electoral roll is 11 days, so that's up till 14 February 2026. Number of days left to complete the hearings is now just 4 days left on 7th February 2026. Number of voters categorized on a draft roll as unmapped is 32 lakh. Number of voters categorized as logical discrepancy post-draft poll publication is 1.36 crores, which is 20% of the electorate of West Bengal. Number of hearings held since, now this is just to give you a idea, since 16th December 2025, which is 41 days, so far they've held 88 lakh hearings in respect of 88 lakh voters, which is at the rate of 1.8 lakh per day. The number of hearings pending is approximately 63 lakhs. And this will mean that if we are to, an endeavor would have to be made, if we have just 4 days left, they will have, the speed of verification will have to go up to 15.5 lakhs per day, because there are just 4 days which are left for 63 lakh. Documents pending for verification at the DEO level in 11 days from 88 lakhs hearing completed. So we have indicated that number. Documents verified by DEOs in 41 days was 52 lakhs. Number of, now just note this because there's a set of submissions here. Number of micro observers deputed without any statutory basis. This is 8,300. I'll just come to that. I'll make a short submission on this micro observers because they don't seem to be contemplated under the constitution at all. Even under their manual of operations, it's a very, very limited role which they have on election day, but not the activities which have been deployed right now, which has been given to them at this stage. Number of approved documents rejected after hearing stage commenced. Now, this is one of our grievances. The panchayat residence certificates, the family registers, the domicile certificates, Aadhaar card, OBC certificates, and land allotment certificates. None of these are by themselves being accepted, and despite orders of the court. And then, Millards, we have mentioned because people are waiting in 4 and 5 hour queues over there. Now, please go over to page 2, para 5. We formulated the specific point here. Now, the first suggestion is non-statutory category of logical discrepancies used to issue notices to 1.36 crore otherwise eligible electors. Now, this is our request. Direct the ECI to upload the reasons of each elector flagged as logical discrepancy cases online on the ECI website. May I request you to directly go to page, we've explained this more fully, but just go to page appendix 1 at page 8 of the same note. Now I'm just giving you an example.
Appendix 2.
My mistake. Please go to appendix 2, appendix 2. Page 11.
Page 11?
Yes. Now, pursuant to your lordship's directions, this is what is being put up. But as you will see, so the name of the elector is there, age, gender, and then the category notice just says DM, which is discrepancy in mapping. But the person doesn't really know when this is put up on those, the reasons are not indicated over here. So what is the reason for this particular discrepancy in mapping?
Mr. Diwan, yes. We were informed that this is on the website, but when the notice is given to the person concerned, the particular...
Yes, I've given you that example. You're right, but there is a lag as far as those notices are concerned. So we are suggesting some short reason should be indicated on this as well, because it will help the process. People will know why are they on that particular list. What's the reason for the list? Yes.
To the extent that person must know the reason.
Yes.
Is absolutely justified. There is no difficulty. The only question is that what is the mode of communicating that reason? What we have been told on the day, because on 19th when we were passing this order, we were also, because we thought that we are issuing very comprehensive direction so that there is every procedural part is smooth sailing. Now we were told on that day that this list is not the only communication. Communication is individual notices to the person included in the list of discrepancies.
Yes.
And that notice can define That notice.
Sir, we've given you a sample in the note. You're right, you're absolutely right. For example, page 9 and 10.
All notices are containing the reasons. The lordships have also permitted them to take a representative, my lord, of whether BLA or otherwise as they want.
Because this will certainly help if it is up there on the note and a short reason is indicated. The notice may carry, given the numbers which we are dealing with, by the time somebody receives it, reads it, etc. So this is my first suggestion.
So for example, page 9 as you are referring.
Yes, page 9, we've indicated over there.
Now, it's due to the mismatch between the name of your father as well as the current electoral roll and as given in the electoral roll prepared during the previous SIR. As per the linkage shown in your enumeration form, you seem to be incorrectly linked with the electoral rolls. I think this is a reason, a well explained reason.
Yeah, so now I want to just take this, I'm obliged to your lordships. Now please go back to my note, just go to page 2. I'm going to now build on this point.
Page 2?
Yes. So, on page 2 of the note, 5A1, I have made the point, then your lordships will see upload reasons is what we suggest. Now, number 2, in 5A2, direct the ECI to withdraw all notices under the category which pertain only to name mismatch. Now, look at this. Yeah.
Page 5, page 5. 5. 5K.
Yes.
This A then close to.
Yes.
Where you are to.
The name mismatch.
Are you referring to the cases, say for example?
Yes.
Just on illustrative basis.
Yes.
So for example, one person writes Datta.
Yeah.
Somebody may may spell it as D-U-T-T-A.
Correct.
The other may spell it D-A-T-T-A.
Absolutely.
That is one part.
Yeah.
And similarly, Banerjee and Banerjee. Similarly, in Sarma, somebody may write SH, somebody may, many of them write SARMA.
Yeah, so your lordships have exactly anticipated what we have set out in paragraph 7A. In fact, we've given Datta, Ganguly, Roy and Ray as examples. But we've given actual examples of what is being faced at page 8.
But now, according to you, you see.
Look at, sorry. One is
tell them to withdraw the notices will be, is something very impractical thing because notices have been issued.
No, I'm suggesting. My suggestion is that our estimate, it's an estimation that in the logical discrepancy cases, please go to paragraph 7A on page 4. Just go to 7A of the note, page 4. A majority of the logical discrepancy cases, more than 50%, which is around 70 lakhs, are cases of minor name mismatches and spelling variations. And we've given the very examples which your lordship. Paragraph, page 4 of the note. 7, subsection, para A. A majority of the logical discrepancy cases, more than 50%, are cases of minor name mismatches and or spelling variations, and your lordships knows. Now we've given you an actually, of actual electors. Please go to page 8. This just builds on the point which your lordship made. Please go to appendix 1, which is page 8 of the note.
Page
8. Now, Mr. your lordship has it. So now Mr. Chirag Tibrewal, his discrepancy was father's name mismatch. My father's name was Kumar in the middle. Your lordship has it. Last column. My father's name has Kumar as the middle name in the 2025 SIR, which was not there in the 2002 SIR. I have been served a notice and called for a hearing on 27th January. Look at serial number 5.
Three, just see three.
All right, 3. Well, let's please see, this is Ajimuddin Khan. Now see what has happened in his case. Father's name is shown as KHA, Alauddin Khan
The Bengali.
in the Bengali, whereas it should be Alauddin Khan. Because you see, from the one from Bengali into English and vice versa, you can lose this. Yes. This may be software.
Illustration number 3 may be slightly difficult because here you are saying Azimuddin. Oh, Azimuddin is.
No, it's Alauddin.
Azimuddin.
Father's name, father's name.
So the spelling mistake is or spelling difference is in the name Alauddin Khan.
No, that's his father's name. Please just see.
The Chandramatra there.
Yeah.
Khan has become. Yes.
But okay.
The 2002 electoral roll was in Bengali. So when they translated it for this purpose.
It can be. All right. What is your solution? Because then we are also thinking.
No, so because there are two ways of looking at it. One is, look, this name discrepancy, my lords, which is the bulk of it, is cramping even the available time, which is just a few days. So these name discrepancies, my lords, should not be within this logical discrepancy to knock out people from the electoral roll, because look at the inconvenience. Look at one of those notices.
Your solution, Mr. Dwivedi, how do you think about it?
Actually, more than a crores hearing have already taken place. Few more which are left.
No, what about this kind of discrepancies which are not even a spelling mistake, which are only on account of how you speak in the local dialect? This happens pan-India. It happens in Haryana also, it happens in Punjab also, it happens in West Bengal, it will happen in Tamil Nadu also.
Yes. So, we don't have instruction being chart given to us just now, it's not there in the IA, etc. But ordinarily, what my instruction.
Mr. Diwan, let's find out.
His name mismatch. Not being
I don't want to interrupt. I don't want to interrupt.
Please don't purge people.
Mr. Sibbal, you are unwell today, you better take rest.
I am going to, but I just want to interrupt. Your lordships will remember, Mr. Dwivedi made a solemn statement, then where is this kind of discrepancy, we're not going to bother about it. Your lordships will remember that. He said if it's a question of spelling this, I'm not going to, this is not something that will be.
Only if you were in Bengal, Mr. Dwivedi, you will be pronounced as Dwivedi. D will become B. And you will also roast it.
Yes, then you will be spurged.
Language doesn't have a war.
Gujarat will become.
Bengali language doesn't have a war.
Sir, instead of my brother being addressed as Vipul, they will address as Vipul.
On this aspect, may I just sorry.
But my name there will be no mistake because it's a basically Bengali name.
Sir, it may be, sir. Sorry, sir.
With your
Because
permission, could we just have an insight over here from? Yes, please.
5 minutes.
If you allow me.
So, 1 minute.
So my understanding was that mere spelling mistakes notices are not being issued.
Are being sent.
But now that this chart is being issued, is shown to your lordship just now, I need to get an instruction. Your lordship may have it tomorrow or day after, whenever I can.
The executive head of the state is also very much present. If the state government provides a team of officials who are well conversant in Bangla and who are well conversant with the local dialect, and they scrutinize these, just scan through this and tell the commission that this is here only a local dialect mistake.
Yes.
and not any identity mistake.
Yes.
That will help them.
No, it will help them, but it's apparent.
Oh, Johnny.
Actually,
Apparently, in some of the cases on illustrative basis, it may be, but it will become humanly impossible for you or for us to go through and to.
Lordship,
May I explain you, sir?
give me time till tomorrow day after, my lords, then I can give that.
May I explain you, sir?
Because in my view.
Because I belongs to that state. I am a.
Can there be any doubt, Madam?
No, sir. No, sir. I am very grateful, sir, because of your kindness, my humble regards to my Honorable Chief Justice, Mr. Bagchi and Mr. Panchali also. Panchali ji also. Thank you very much. And my humble regards to Mr. Dwivedi and others, my opponent lawyers also. Sir, the problem is, always our lawyers fight for the case and they are fighting from the beginning. We are also. But sir, when everything is finished, when we are not getting justice, when justice is crying behind the door, I quote Rabindranath Tagore, then we thought that we are not getting justice anywhere. So many times I have written 6 letters to Election Commission, including all the details. But no reply, sir. I'm a bonded labor, sir. Maybe I pay for that. I'm a very less important person. I pay for that. Sir, I'm from a common family, but I'm not fighting for my party.
Madam Mamata, sorry for interruption. The state of West Bengal, in its own right, has filed a petition, right? Today, of course, you are also coming in your individual capacity, but state of West Bengal, in its own right, there is nothing wrong in that. State of West Bengal has also filed a petition.
State of West Bengal has not filed.
One of the best counsels in the Supreme Court, fortunately, are there to not only are to represent the case of the state. Mr. Sibal appeared on that day. Today also, incidentally, Mr. Diwan is there. Then in the other matter, Mr. Gopal is there. The best of the team, the legal team in the Supreme Court is there to assist us in the matter. Mr. Sibal goes slightly relevant.
Sir, if you allow me 5 minutes only.
Now he is there.
Only 5 minutes only.
We will give you, not 5, we will give you 15 minutes. We are only pointing out that on 19th January, when the matter came before us, Mr. Sibal very eloquently he explained the procedural difficulties which the state was experiencing and where the state had some genuine apprehension for exclusion of the bona fide citizens of the India, citizens of West Bengal, the residents of West Bengal were citizens of India. So therefore, those directions, the direction which Mr. Diwan just read out were issued. Today, in your petition, some additional issues are being flagged. Absolutely right. Issues are being flagged. Every problem has a solution. So we must look toward the solution in order to ensure that no innocent citizen is left out. This SIR is based upon only on 3 grounds. Dead persons excluded, no difficulty, neither you will want, nor anybody will plead for the dead persons. Similarly, the persons who are disqualified to remain for any reason, somebody is convicted, whatever may be any ground in the law, you will not plead their case. Similarly, those who, migrants, the word is migrants is also one of the ground. Those who have left West Bengal, even you will not plead there. But the genuine persons must remain there. Now, among the genuine persons, one of the ground, as Mr. Diwan has today flagged, and rather we are thankful to you also that in your petition now this issue has been raised, that because of the local dialect or because the manner in which the Bangla people will proudly pronounce a name or because of that, and this all because nowadays AI assisted computerization, that you are speaking Datta and they are recording something else. If this kind of things are happening, we will find out a solution. They will have to find out. They can't. They will not like to run away from that responsibility. That by virtue of this kind of mistake, the genuine and bona fide person must not be excluded.
Sir, what happens now?
Only one.
Sir, what happens now?
Permitted before they could open millets.
insofar as the Election Commission of India is concerned, I represent. In that matter, so far we have not been served with any pleadings. We are clueless what their grievance is. If it's been there, if it's served on us, a week's time given, we'll get all instructions, we'll place it before your lordships, and look forward to any genuine difficulty to be redressed.
Which time will be too late?
So be it, minutes, let it be on Monday.
Which time let them?
Let it be on Monday.
Sir,
Because millets were clueless, what the grievance is.
sir, this is not,
I understand.
Item
This is-
21 is
please
the-
allow me, sir.
There's a reply in
It has not
21.
been served.
You are right in saying that you have not been even given copy because
No.
the matter is coming first time for hearing.
Indeed.
The only thing is that since all this entire procedure has a timeline, at that timeline, we had extended on 19th January for another 10 days.
True minutes.
But that 10 days time is also now, because they rightly pointed out by Mr. Diwan that out of that extended period, only 10 days are left. 4 days are left. After those 4 days, only 11 days are left. So this being a timeline, we can't grant you the luxury of 1 week notice of.
Minutes on Monday, so that, sir, we'll come to know what the grievance is and we'll suggest or place before your lordships the remedial
Sir,
measures.
please allow me to finish my point, please.
In principle,
Yes.
if it is happening that Roy, Datto, Ganguly, Upadhyay, anyone like this, by virtue of the local dialect, if name is being spelled out slightly different than what the accurate words might be, somebody can say.
Precisely.
In a given case, we do not know how Tagore is also defined. Maybe somebody put the E in the last, somebody may not be putting E. But that does not mean Tagore is not Tagore.
Millets.
So you also have to
Millets.
come out with a.
What they cannot
technical
afford
way
to
of
forget.
So as the state can suggest us, so we out. We will.
Millets, even the field staff are local, they pretty much know all
Respected
this.
Chief Justice, sir,
Not that
I am
someone imposed.
giving you the example. I can show you some photographs. If you allow me, only I want to submit, sir, I want to lay, because it is not my photograph. All the Bengali leading newspapers, it is reported, you will be surprised to know the, sir, only sir, my submission, sir.
No,
Sir, their SIR process is only for deletion, not for inclusion. Mismatch, not only the title, sir. Mismatch, mismap, unplanned. Now suppose a daughter after marry, she go to the in-laws house. Now why she's changed her title? Why she's using the husband's name, husband's title? That is also mismatch. Yes, sir, they have done it, sir.
That's why we are.
Now,
That's
sir,
why we.
only I just want to, sir. Number two, sir, there are some daughters who married and shifted the in-laws house. Their number also just unilaterally deleted. It is just because they shifted their houses. Sir, you will appreciate, sometimes some people work some office, they go to be, they transferred other offices, they work somewhere. Sometimes the poor people, they purchase the flats, they shifted their addresses, but they are the genuine people who are staying there. But because of the name of logical discrepancy, now they change the name. Instead of logical discrepancy, when you gave order, sir, they violated and they say it is the discrepancy mapping. Sir, can they even violate your order? Number two, sir, we are grateful. Bengal people are so happy that this court gave order that Aadhaar card will be one of the proof documents. But they said no, on with Aadhaar card. Sir, in other state, sir, the domicile certificate is allowed. Sir, the family registered card is allowed. Sir, the government housing card is allowed. The health card is allowed. The bank books means whatever caste certificate is allowed. Only they targeted Bengal on the eve of election. Sir, 4 state, opposition state are going for on the eve of election. But why? After 24 years, what was the hurry to do it? What it takes 2 years, only within 3 months, even when the festival season is there, when the harvesting season is there, when people are not in a mood to be in the city, they were in the outside, but they are traveling, and that time they issued the notices and all this. Sir, more than 100 people died, sir. Can you imagine? Sir, BLOs died and they have written the letter that CEO is responsible for my committing suicide. So many BLOs are murdered, they died. And also more than 150 people died and so many are hospitalized. Sir, because of the harassment of the people, because of Bengal is targeted, sir. Sir, you tell me why not Assam? Sir, why not Assam?
The state government, we cried foul, saying that.
Why not Assam?
Any cooperation. They say.
Why not Northeastern?
Madam has come all the way to speak something.
Indeed, my lord. But the only thing is that, my lord, if it's off the record, we need to.
Madam Mamata,
Yes.
let me clarify 2-3 things to you. About the Aadhaar card, this matter, about SIR's validity issue. SIR's validity issue is being argued before us from last more than 2 months. In the main judgment, which was the first case, we have reserved the judgment. Therefore, we are not in a position to comment with regard to the credibility, credential or admissibility and to what extent about the Aadhaar card. That issue has been argued before us. We have reserved the judgment. But you also will appreciate Aadhaar card has also its own limitations when you will read that statute under which it is issued. At the same time, with reference to its insertion in the RP Act, what will be its value? We are yet to determine that part. You have one part. Second, you have pointed out this issue of the discrepancies part. In this case, one way out can be that you give a team of officers, the election commission can take them on deputation in the sense that those can also be part of the election commission team, verify that here it is a spelling mistake or it is only because of the local dialect that this mistake is occurring. Those must be rectified. That has to be rectified. So let us see what response they will give. We will grant them 1 day time. Tomorrow or after.
No, sir. What happens, sir, ultimately, in practical, ERO has no power now. They have superseded all the power from DO, ERO, BLRO. Only they have appointed 8,300 micro observer and the role observer from the BJP rule state, so that DO cannot clear the name. It is all micro observer can delete all the names sitting inside the election commission office through AI. Sir, earlier 58 lakhs are being deleted. Even they were not allowed to file Form 6. Sir, earlier first phase, 58 lakhs deleted. There are so many people are alive and now they are being declared that they are dead. Sir, the anti-women, so many women.
Madam Mamata, if need arises, we will mandate it, we will direct. Every document will have to be signed by the BLO, who are the authorized officers and who are the authorized notified officers.
Kindly see the directions in the website, Millers, so far as the so-called micro observer.
Micro observer is a final authority. Election commission, WhatsApp commission. WhatsApp commission is saying it is only the micro observer. Only they are deleting all the names.
They could certificate on record.
May I just take you?
They are all government of India officials.
My lord,
They are-
even
Lord, in one of the matters, government is a party. Lord, let
But the problem is that they are not allowing the people.
the matter.
They are not allowing the
Legal domain.
state officials.
Possibly for most of the submission.
They are not allowing the domicile certificate.
Day after.
They are not allowing the government certificate.
let that be a direction, Millers, we should be served the copies.
May I just highlight?
I have something.
Yeah, I just want to highlight 2 points. If your lordship would just take up, I want to save time, so just go to my note for a moment. Just go back.
Lord, I want to intervene for 1 minute, Lord, if lordship permits, Lord. We have written several letters to the state government to give us Group B, Lord, the class 2 officers of the rank of SDM or equivalent, so that, my lord, EROs can be appointed. That's the standard pattern, my lord, that they should be class 2 officers because they decide vital rights papers and all that.
No, that has.
Now they have given, my lord, only about 80 officers of that rank. Rest, all of them were given who were clerks and below, who are working under the pressure of the state government. Therefore, we had to appoint, my lord, micro observers who can assist, my lord, in case, my lord, they are in the confusion. So the fault lies with them in not giving us class 2 officers for performing the job of AERO and ERO. So that's the reason why this is happening. And these micro observers are validly appointed under section 13C read with 3.
No, there is no statutory rules.
my learned friends are not right, my lord, that they are not, we are not entitled to appoint them. If this is the state of affairs which is not contemplated by the rules and the state is not cooperating, then there is no alternative except to appoint the observers who can assist. Class 3 officers from Anganwadi and so on, they are being given to us. So that's
And
the
this is the
reason why
communication.
the assistant.
There is only one.
But they are not assisting.
There is
They are
one,
taking
one,
They are
lordships
taking
have
decisions, not
one side of the story. May be true, may not be true, I'll not go into it.
So
There is one more petition where the Election Commission of India has filed an affidavit. That also may be taken on record. It's not listed on board. It was mentioned by Mr. Giri. But I am appearing in that matter and I have read the affidavit. So that also will have some bearing, my lord, in ultimately what your lordship passes the order.
And we have highlighted all the
just-
difficulties we have been facing, millets.
My lord, my lord, my lord.
My lord, it is pointed out the
Yeah,
hostility.
just
which
have
is
2 minutes. I just
But a role of
I just want to
observers are
highlight.
a victim, that's all, my lord. I am saying let us confine.
Ultimately, we
No, no.
will ask them to at least 2 days time we'll have to give to
Yes,
them
yes.
to seek their response.
Sir, matter is not correct, sir.
Survey copy, millets.
But fair enough.
Wait, Amma-
What I'm highlighting is
There
just
is no
2 things so
problem.
that your lordship sees them.
Let me say this, there is no problem of time, my lord.
The first,
Have some buffers if there is
अरे भाई, ये तो-
more than 1 crore already heard. And if somebody is not heard, your lordships are there and we
We
are,
will
our
grant it.
power is
We
there.
have been extending time. We have been extending time. We have
Millets,
been-
my lords have passed a slew of directions.
My lordship,
Every
my
aspect-
lordship with my humble regards. May I tell you, sir?
Whatever they have pointed out
My
and my-
opponent lawyers raised.
Said that.
Sir, that is not correct.
Madam
That is not correct, sir.
Madam Mamata, we have no doubt about the ability of Mr. Diwan. He is one of the best senior counsel you have chosen.
Yes,
Let him
with his
assist us
permission.
on your behalf.
With his permission, sir. Only one thing, sir.
Your point we have well taken.
Sir, it depends on some district,
Kindly
some
give
states,
us
sir.
the-
We have suppose 44 district, we have 23 district. Now SDM is depends on the district wise. Now whatever we have the strength, we have included all.
Alright.
We are
Are you-
cooperating to them
Are you
all.
prepared- are you
Micro,
prepared to provide class 2 group?
yes, we have given, sir. Whatever they ask,
Alright.
we have given, but they are telling
All right, please.
what I don't believe.
I think we will be able to find out a practical solution.
Very well.
On Monday, when we take up this matter, we are granting them 2 days time to have instruction based upon these, all the notes and information which you have gathered.
Very well.
And you also on Monday, please give us the list of the group B officers which you are in a position to spare
Yes.
and to provide to them for their
Furnish it in
assistance.
advance.
So that,
And your lordships may list that matter also because
Yes.
there is direct bearing on that.
ICT.
There is an atmosphere of hostility, Election Commission says.
And it contains all our communications to the
But with
government,
Written
trying for
communication
help.
is contemporaneous.
issue notice.
Lords, I have one apprehension, that's all I have. I don't want Mr. Dwivedi coming on Monday and saying, now we have finished 1.2 crore hearings as a figment of his.
It's all right.
Numbers.
We are entitled to our defense.
That's what you're saying.
That's an ongoing exercise that will
Sir,
continue.
only my last submission, sir. Sir, whatever they have only asked us 58 lakhs deleted. They didn't have any scope to appeal even Form 6. Number 2, the second phase, 1 crore 30 lakhs. Only my request would be, whatever the system is maintaining the other state, they are only targeting Bengal. Only for Bengal, they appointed these micro observers.
Not the forum, millets.
Yes, for to bulldoze the West Bengal people. Sir, my humble submission will be, sir, the logical discrepancy case not to be deleted, and there should be, as it is, it should be cleared by the DO and the ERO, not with the micro observer, not with the role observers.
Millets, they as well see your lordship's directions on the last occasion.
So give us the list of the officers whom you can spare.
Yes.
Whom you can spare.
Yes.
Probably, once the officers are made available.
Yes.
Then micro observer will not be required.
Not be necessary, absolutely.
Millets will,
Yes.
Yes, absolutely.
Can do it.
whatever the
And on
rule they
Monday
are
itself, we are taking up the matter on Monday. Meanwhile, they will also get instructions and you also give us that list.
Very well.
Mr. Diwan, please ask your junior to give
Yes.
complete set of paper book.
Of course.
In both matters, we'll.
Both matters. And in Mr. Gopal's matter.
To item 37.
Yes.
Learned in.
Or with my humble regards, I convey my great regards,
Personal fame.
and I will just tell, save democracy.
1 minute, madam.
Joy Goswami, he is a renowned author, Jnanpith Puraskar awardee. There might be some mistake, please, you tell your officers also to be a little bit sensitive.
We'll examine, my lord.
Don't issue notice to persons like.
We have never been divorced from common sense.
They are unnecessarily embarrassed.
We are addressing
There
them.
is some
If they
extra
want
time
to
is
make
required to be
sensationalism,
spent.
that's
No,
it.
just one last thing I want to flag. When we argued the merits in Bihar, your lordships noticed this logical inconsistency, etc., were not issues there. The problem is, every time a new state comes up, there will be a new issue which has absolutely no constitutional.
Every day changing the
Each
decision.
state may have its
Now,
own
after
problem.
this, it will
As
come
they have
up.
been creating.
New issue.
Yes.
Every state will have some new issue.
Exactly.
It is bound to be also.
But
because
it has to have a legal basis. Without a legal basis, they can't start examining something which is not from the draft
The
code
state
at all.
government fights the constitutional
issue
body,
notice-
what could be the legal
Issue
basis?
notice in both the matters. Issue notice, can assisting counsel wants to accept notice in behalf of the Election Commission of India, wants to accept notice on behalf of the three electoral officers of West Bengal. Once we have briefly heard from Shri Shyam Diwan and Gopal Shankar Nair, non-senior counsel on behalf of the petitioners, and so Mr. Dwivedi and Rakesh Dwivedi and Mr. Naidu, non-senior counsels representing the Election Commission of India. During the course of hearing, it is pointed out by learned solicitor of India that there is another petition hearing number so, and the issues raised therein or the affidavit filed by Election Commission of India will have some bearing on the merits of these cases. Consequently, that order, petition is also ordered to be taken up along with these cases on Monday, with the date of the Monday. The parties shall have respective instructions on the date fixed.
Great.
Take up on Monday.
Grateful.
Thank you.
Sir, we are very grateful, sir.
Grateful, madam.
No, of course, sir. Of course, sir. Please protect the people's rights.
म्यूट कर दे।
Hmm.